hearing is what is happening. Okay. Map detect. Actually, for teaching assisted content material, yes, the eviction matter. It's better put so that they have to.
Contempt is unlisted. Why? Come up tomorrow.
I don't have it meant for
Mr. Islam, in your matter, yesterday they didn't do anything as regards those petitions. As regards the petitioners, yesterday I passed an order. There were 2 writ petitions, you remember? Have they done anything?
one district, one petitioner has demolished, and another is not.
No, yesterday.
Yes, sir.
Yesterday petition also they have demolished.
One South City 137. Second,
At what time? Before the order passed?
it's informed at 1 p.m. They have informed us.
The other has not been.
Other it's another side. Up to 4 p.m. they have demolished, but one side. And another distance, 1 kilometer distance. That side is not. Day before yesterday, covered.
Huh?
Three petitioners there. Day before yesterday, 3 petitioners there. It was the page. All the demo.
No, day before I'm not concerned. I'm saying
That is one petitioner.
has been demolished.
Up to it's 137.
Okay. We'll take up your contempt matter today.
I bit for listing my tomorrow.
Why?
I thought public matter the fight matter what matter
So, what is the urgency tomorrow? There has to be some urgency.
but I thought someone is good. I thought the petitioner by the party the people here after the finance. By the finance by the file case complaint case by the one and Calcutta. I mean I thought the appropriate minister by the dispute the common.
Okay.
All right.
My lord, in item number 4, APDCL has filed an affidavit yesterday, my lord.
Hmm.
I'd like to file a reply. Can it be taken up on Monday, my
Monday it's closed.
No, Monday is a holiday. Huh? Yeah. Tuesday. Tuesday. I'm told Mr. Indranil Chaudhary, who appears for, he will be not there on Monday, on Tuesday, my lord.
Monday, Tuesday is closed.
Also, how do you get it? Sorry, 18th, my lord. I mean 18th.
18 many matters. 19th.
Deeply.
Hmm?
Item number 17 for John.
Yes.
But we take it up.
What should I do?
Doctor matter for the.
Why?
Senior.
Senior? No senior. Next.
Kindly after vacation.
If it does not reach, you are very fortunate.
I
beg to mention for the distinction of WP 5763
For what?
there's the urgent similar matter has already been disposed by this.
When? The matter is listed today?
No.
It's
for
listed
distinct.
tomorrow?
No.
Then?
After vacation of
Why?
vacation for this.
Huh?
Similar matters have been like after
Okay. After vacation, give a date.
I have not query.
Hmm.
Not query. Tax is what?
No, why there are why I
One
have
second,
said,
my lord, he doesn't inspire any confidence. Let us, my age, I told my learned friend, it hardly matters. But when I see and when a query was put forward by your lordship, I call the crime. What is this? I have to tell your lordship the truth. Hardly matters for me, my lord, at my age, my lord. It is not, I maybe have the best of best world so far as the law is concerned, but what about the facts? Your lordship has gone to the facts. It doesn't inspire any confidence on the facts, I am telling your lordship.
and more particularly,
Yes.
you see why I'm saying it like this. If you take out the file,
Yes.
I'll show you the
Yes, I have, lordship will kindly.
finally come to paragraph 2,
Paragraph 2, my lord,
page 5 of the writ petition.
page
Paragraph
5, paragraph 2. Yes,
This is your objective
one second.
for which you are going to,
Right, absolutely.
and this is the basis of your objective you said that have applied for.
Correct.
Okay. You applied on 7/7/2004. Okay. While 7/7/2004 was going on, then you move an application to the Minister of Revenue on 7/4/2004. 5.
Right.
On 7/5/2005, the Deputy Commissioner, on 7/4/2004 itself, the Revenue Department instructs the Deputy Commissioner to take appropriate steps. On 7/5, the report has been submitted to the authority. The DC takes steps, and a report thereupon is being submitted that this land was actually given to KCC Commerce College. However, as it has another plot of land has already been given to KCC Commerce College, under such circumstances, this land can be allotted. It is okay. I am not worried with those facts. Then on 13/9/2005, the land has been settled with you.
Right.
You pay the premium, and on 5/10, the record of rights are corrected. 6/10, patta issued.
Correct.
Yeah, it's
Right.
okay. Thereafter, you see, in the meantime, interestingly, there was a stay order. It's a different thing that the division bench did not go into that aspect, but the stay order was there, and under such circumstances, the respondent authorities ought not to have. It was in clear violation of the stay order passed by in the PIL that the allotment was made. That was the reason for your first cancellation on 38. Your ground is, look here, you have not given me a notice for which you have cancelled, for which. The division bench, by its order dated 7/7/2007, 24/7/2007, did not go into that aspect of the matter. However, said that as they have paid the revenue, patta has been issued, so a right has been there for which, if anything is to be done, you have to issue a notice. Now the things says like this. Now kindly come to your annexures. In the meantime, you do not do anything. You seek for a permission for construction.
Correct.
Now kindly see the construction permission.
State.
I'll show. Kindly come to page 82.
Yes.
Respectfully, I beg to state that I have submitted an application on 29/7/2010 for and on behalf of this society,
Yes.
seeking permission for construction of building of the society, and in terms with the said application, I have received receipt number so-and-so, book number so-and-so. Now you see the corresponding document in this regard. Kindly come to page 187. This is the application which you are making a reference out here. To this at page 82,
Yes.
this is the reference, this is the application you are making a reference. because at page 188, you will find the receipt number as 809629 or book number 8097.
Yes.
So this is the reference we are making.
Right.
Now here, it is not an application being filed by the society. It has been done by a power of attorney holder.
Correct.
Okay. Now kindly see this. So this is the applications which we have filed and you have been saying. Now thereupon what happened? They issue a notice to you after 3.5 years saying that you have not made any construction. So under such circumstances, you reply, "Hey, look here, the construction we have applied to the GMC has not given us the permission, and as such, how can we make the construction?" So the reference again comes to this application which was filed on 29/7/2010. Okay. Now, thereupon, they cancelled again. Matter comes up, another writ petition filed. As there were some other grounds which have been taken, for which the order of cancellation was not set aside. However, it was kept state, and the grounds which have been taken in the order of cancellation, you were required to submit a reply. Now you submit a reply on 28/12/2012, page 101.
Yes.
Kindly come to page 102,
102,
paragraph 3, Roman 2.
Roman.
Yes. Kindly read.
The
if you-
application requesting permission for RTC building construction for constructing showroom, exhibition center, modernization factory and residence unit on the state land was made to Guwahati Municipal Corporation on 29/7/2000.
Again, the
Right,
same
right.
one.
And as required, the society has also paid a necessary processing fee for grant of building permission together with a plan and estimate under the authority and signature of the secretary, Purvakta Udyog Handicraft Cooperative Society Limited.
Which is again false.
Yes, right. A bare perusal of the proposed building plan will go to show that the same has been designed only to promote and encourage handicraft activity. The proposed plan envisages 3 RCC building over the settled land of building 1, building 2, building 3. The proposed building 1, which assumes top priority over the other 2 buildings, is exclusive designed to house the handicraft showroom for showcasing the locally manufactured women produced handicraft. It is designed to cover the entire permissible ground area of so and so handicraft exhibition center, modernization factory. Also to showcase the item and whole exhibition will cover the entire permissible first floor area of so and so, with the second floor to be utilized as a society office cum hall, covering the entire permissible area of so and so. Proposed building number 2 and 3 have been designed to be set up as a car parking area on the ground floor and residential unit for the members and various staff employees of the society. Proposed building number 2 will consist of 4 residential units on each floor, whereas the proposed building number 3 will consist of 3 residential units on each floor, as written in the site plan map available with GMC authority. To reiterate that the said residential units are only meant for use, occupation, utilization by the members of staff employees society who are dedicated integral to the promotion of the Solomon object of the society.
Now, you see another very important aspect of the matter.
Yes.
We come to your affidavit in reply filed on 3rd of March 2017 and more particularly to paragraph number 13, page 159.
Yes. One 159.
This is what
Correct.
you have repeated. I would not ask you again. This is exactly what you have repeated.
In that
In
particular.
paragraph
what the
3.2 and
3.2 and
3.3
3.1
has been again repeated on affidavit by your person.
Correct.
Now, on the other hand, the permission has been applied on the basis of the irrevocable power of attorney. Kindly
yes,
come to
yes.
page 189.
That I am marked. Power of attorney at page
89.
1 second, 189 minus.
Yes.
Yes.
189 or
189.
190.
Not 81.
190.
190.
Yes.
190.
Kindly see,
Yes.
this power of attorney is given to Bhuya Projects Private Limited and to the director is Ripun Bhuya.
Right.
Now kindly see from Ripun Bhuya, What is the power given? To develop, cause at page 192.
Yes.
Develop, cause and conduct necessary survey through proper authorities, 3 bighas of land, and this is that. Then,
To construct, now
Yes.
number two, to construct, build multi-story commercial, that's what your lordship was
a
saying.
modernized factory,
Residential foreign factory, restaurant, so stop over the stop, so and so.
yes. Then you kindly come to number 4 is to make the application.
Yes.
For
Four.
which you have made that application, that
Right.
Ripun Bhuya had made
Yes.
the application. Then you kindly come to here, number 9.
Number 9. To authorize the proposed buyers for the residential flat, commercial shop cost of the building, to mortgage their portion of flat top to any financial institution, bank, any other financial authority authorized for financial assistance, and to enter into agreement with such proposed buyers of the flat shops and also for modern factory.
Then number 10,
Number 10, to sell, resell, lease out, let out flat shops and spaces of proposed multi-story building, parking space and utility space for the buyers of the flat only, and also attorneys shall be entitled to sell or transfer anyway in any part or full of the commercial portion modernized sector of the proposed building.
so
Which is contrary,
To
which is
what?
contrary to what the purpose which was given.
not only that, what you have stated
Correct,
in
you
your
see, in the
affidavit
affidavit,
at paragraph
that
13,
10232,
yes,
32.
where you have categorically mentioned that we are not going to use that for anything, but you are allowing this to sell. Now kindly see beyond this,
Yes.
another power of attorney has been executed. This is exactly the same contents of which.
Yes.
Now here is the permission at page 207,
207.
7, the application which was filed.
207. Yes.
Here, ground floor is parking and commercial,
1 second. Ground floor is parking and commercial. Yes.
then residential, commercial,
Correct.
first floor,
Yes.
second floor, third floor, and then fourth floor onwards, all are residential.
Right.
Now, apart from that, what you see here is a very interesting thing.
Yeah.
Your affidavit in reply filed to this affidavit.
Yeah.
Your specific thing out here is at paragraph number 6, page 217.
217 paragraph
6.
that with regard to statement beneath paragraph 3 of so and so, the answer as deponent strongly denied the same and further begs to say the aims and object of writ petition society was set up with a view to provide succor and livelihood of the unemployed youth, widows and distressed women, and to impart training and to undertake activities for manufacture and sale of bamboo and cane product, and also for imparting skill training in embroidery and design items. With a view to reach the stage of self-sufficiency, the petitioner society took up the task expanding its activities so as to able to manufacture products of high quality, which can be exported and sold at reasonable price within the country as well as outside the country, and also be able to compete the international level, for which a structure was needed for storeroom and accommodation of training staff, etc. So for the power of attorney, these as well as the agreement are concerned, they were already cancelled by the writ petition by execution. Revocation deed about which intimation was duly given to Messrs. Bhuya project by notice duly sent to register post, which was duly received by so and so. And the same was very much within the knowledge of Messrs. Bhuya Project Private Limited. And it was duly been intimated before the office of Senior Sub Registrar Kamrup at Guwahati by letter dated 6/2/2012, which was kept as Sub Registrar case number 5 of 2012. Messrs. Bhuya Project Private Limited has approached before the Guwahati Municipal Authority for obtaining permission, deviating the terms and conditions of this and by playing fraud, that too without knowledge of writ petitioner. And when the petitioner came to know about the whole fact, all the deeds were cancelled. A matter was also brought to the notice of Guwahati Municipal Authority by the objection, which was duly received by GMC Authority. But the impugned cancellation order dated now was issued only because the fact settlement was proposed to cancel, only to give the same to GMD Authority, whereas the government by letter dated 13/9/2005 settled the land in question holding. Land in question was settled for establishment of modernizing factory, etc., subject to fulfillment of the NGO status.
Now you say that there has been a deviation.
Yes.
Where is the deviation? You have allowed the particular person to construct, sell. Where is the deviation? There is no deviation. On the face of it, this statement is wrong. Now kindly come to what you have enclosed. Kindly come to page 220. What is the letter written?
20.
Yeah.
Yes. Revocation of power of attorney. With due respect to and so that our former chairman, the Munin Sharma and secretary made an agreement with Bhuya Project Apartment on 25/2/2010 and also actually registered deed of power of attorney by dated so and so before the office of Raj Registry Guwahati. We severely instructed to Mr. Bhuya Project do as per development agreement, but Mr. Bhuya failed to do so. That when Mr. Bhuya Project failed to comply with the agreement dated 25/5/2010, they had insisted as for a fresh agreement for which the previous agreement was cancelled. Agreement was signed which was registered on so and so in spite of unwillingness of us. Due to the
So,
above fact,
as 25/5/2010, those
Yes.
power of attorneys are of 25/5/2010 nearby.
Right.
So these power of attorneys were executed. Now that you are cancelling because they are not abiding by it. Now on the other hand, it is your specific case in those agreements also. If we see the power of attorney that you have allowed them to construct and also sell it. Now this is, and what is this revocation deed? Kindly see at Annexure 2, page 222.
Yes.
It is well settled that when a registered document can only be cancelled by another registered
Correct.
instrument.
it notary it doesn't have any value in it. It is only by an instrument it has to be cancelled.
Yes.
So as on date, this power of attorney doesn't have any particular, it will stand because it has to be executed by a registered instrument. It has not done as such.
Now kindly come to page 225.
2 to 5.
You have not asked for cancellation of the permission as sought for. You have only asked that a permission should be given to you. Kindly see this.
With due respect, I beg to say I am the secretary of so and so. Society has applied for construction permission over the fancy bazaar land of your authority has shown name of Ripun who has applying in the money received. The name of the applicant should have been Purbato Udyog, a handicraft represented by secretary. While the above facts came in knowledge and the society called
Hey,
meeting
Ketan.
and resolved, the GMC commission has given written information in the final NOC construction permission. Name of Ripu may not be included. Agreement between society and Ripu no longer substitute due to failure to stick to terms and conditions such agreement, or they may issue NOC to the society. This may require.
So you are sticking on that particular application wherein you have not sought for any building of for this construction to that those aspects, but you want the permission in your name, which is again in violation. Now kindly come to the IA file. Not এখন নহয়, আৰু এখন আছে। IA 1525/2021.
The name which has been changed.
Yeah. Now,
this is, my lord,
Huh?
this is most disturbing.
Not
Because
only
no,
that,
No. Ripun, yeah.
Mr. Das, not only that,
Yeah.
kindly come to page 10 of
Yeah.
the resolution.
Yeah.
Page
IA of
IA 1525.
1525.
No, did you?
I got. 1525 in WPC 2321.
Then there is not there. That IA is very innocuous.
Oh.
Nobody knows what it is.
Oh.
Then there is an additional affidavit file in that IA.
Additional affidavit.
Kindly come to page 10 of the
Page 10. Page 10. Yes.
resolution number 9.
Number 9. The House entrusts the President and Secretary to file Honorable Guwahati for recovering the land of court measuring 3 acres of government and decide that if the land is relocated in the name of court, it will be sold and loan of the court will be repaid with the certificate. Absolutely.
Now, why this to be spoken to?
No,
I
now-
could have very well dismissed it
No,
on this
I-
ground.
no,
The
I
reason
think
is
my-
one very important thing which needs to be deliberated upon. Is yes, once a settlement order is given, the settlement order can be cancelled. There is no quarrel, and that Sifat Ali judgment has also been taken care of by the full bench judgment,
Yes.
wherein although I didn't read it at that point of time when the hearing was there, but if you see at paragraph number 18 of the said judgment, it categorically mentions that a patta can also be cancelled in consequence to a cancellation of a settlement. That the full bench has already taken care. And I have also recently held that the natural corollary of a cancellation of a settlement would be a cancellation of a patta. So that is also well said. Now, a settlement has been given. This has a merely by saying that if they don't do anything or they do something which they are not in a position, just for example, today the land has been settled by the government to a particular school, which is normally in a what you call a composite zone. Now, tomorrow, the Guwahati Metropolitan Development Authority comes up with a master plan that look here, this will be a green belt. Now, can they take over the land or cancel the patta? No, because that cannot be done. But on the other hand, then once a settlement is given, rights under 300A confirmed. But if it is a case where for a particular object, you have fought for the permission, a settlement. And that object, beyond that object, and later on, it has come to light that no, the object behind which you have taken was misleading. It was just playing a fraud upon the authorities concerned. Then in that regard, would the cancellation of a patta be not, settlement be not allowed by the government? Because you see, the settlement rule 1 categorically says that all settlements or anything shall be subject to some general or special orders of the government. So it is in that delicate balance to be maintained. That is why I have
No, he's right. Your
fixed the
lordship,
matter.
so I have gone, whatever your lordship has said. Then now, the question being, my lord, that special power of attorney, that becomes irrelevant because it has not been. Now, can it be? Just I am putting it, my lord. Can it be like this, my lord? Subject to your lordship, my lord. This power of attorney by this society goes and cancel it by an instrument. So it goes. This person, Ripun Bhai, is out from that seat, he is thrown out from that as a chairman. Number 2. Number 3, my lord, subject to giving undertaking by the court of this society that it is only will be used for that purpose, not for any other purpose. All these are to be placed before the court before your lordship takes a decision. This is only my suggestion, my lord. But facts, my lord, I am telling your lordship, it's a worst.
No, I'm not on these facts. These facts,
But it's
because this court is going to, because there is a larger question involved. The larger question involved is what is the scope of cancellation of a settlement? You see, patta, which although the division bench held it, however, the full bench had duly corrected that. Patta is nothing. If you see section, I think section 11 or 13 of the Assam Land and Revenue Regulation, it categorically says the patta only gives the right how to exercise or regulates the settlement. And you have to keep in mind that these revenue laws have been made in 1986. At that point of time, giving somebody a settlement is a headache for that person because he has to pay the revenue. Nowadays, for paying revenue, everybody is very happy to pay the revenue. But at that point of time, paying revenue is a headache. So therefore, you have this auction sale and all these things concept. But even if it is a case of auction sale, therefore the concept of cancellation of a patta is not there at all. Neither the act, the regulation, nor the rule, there is a concept of cancellation of a patta. It is not. It is for auction sale, for sale of a patta. And if you see the provision of the rule, I think that particular rule, the section itself, 75 or 82, it categorically mentions that if whatever amount is being found on the auction, if a particular amount is more than the revenue, that quota holder is to be paid that.
Now, one aspect of the matter, my lord, I must bring it to the notice of this court, my lord. Regulation 11 of the regulation, my lord, rights of settlement holder. A settlement holder who is not a landholder shall have no rights in the land held by him beyond such as are expressed in his settlement lien. Now, here, my lord, page 47 is the settlement order. It is not a patta, lordship. This is the Zenas. Now, here, my lord, it is specifically stated, but a condition precedent is, my lord, that with reference to your letter, so and so, I am directed to say that the governor of Assam is pleased to order for settlement of Sarkari land measuring 3 bighas, so and so, in favor of Purvutto, Widow, Handicraft, Cooperative Society, for establishment of modernized factory, etc., subject to fulfillment of NGO status of the organization and subject to payment of 30% of the value of premium. Now, 30%.
So that will be the term
Yes, that will
of
be the,
settlement.
yes. Now, my lord, my argument, my submission is that they have duly paid 30%, no default. But the other two parameters, the other two condition precedent, that they will set up a modernized factory that has, my lord, tax lordship has changed. They have not, my lord, it was not their intention. So 3 conditions for settlement: modernized factory, then, my lord, NGO status, then 30%. 30% they have fulfilled. Rest 2 they have not fulfilled. So that means, my lord, the settlement for which it was meant, my lord, if we read it with the regulation 11, my lord, they cannot use the land, my lord, beyond what has been settled, the terms of settlement.
No, understood, but you have not put a period.
Period is not there.
That is the problem. Period is not there.
Period
So
is-
therefore, I am not on this particular question on period. There is no problem in upholding the order of cancellation. There is no problem out there. But the fact remains, a larger question therefore arises as to when a settlement can be made.
Yes.
Cancellation, the settlement can be cancelled.
Yes.
Yes, a settlement being given. The proposition which I want to forward is something like this.
Yes.
That is what I was, that is why I fixed it. A settlement is given on further right
Well.
under 308.
No dispute. Yes.
Now, if you see, have you read the judgment of Justice Nagaratna in the Pilki Banu's judgment?
Yes.
A very beautifully put paragraph. I think it's just in the end of the judgment. It says Article 21 cannot be taken away without the authority of without save by authority of law. Article 21 cannot. So these people whose remission was cancelled, meaning thereby now they will have to go again back to the. Now the question is, would that not be affecting Article 21 because the liberty would be constricted? So the Supreme Court say here that no, Article 21 confers a right that shall not be taken away without due process. Similarly, for enjoying the right under Article 21 also, it has to be by way of a legal act.
7 except by.
No, it has also to be conferred by a legal manner.
Yes.
So, therefore, let us not go into the other aspects of the matter because directly or indirectly, the settlement being given 300A is something.
Absolutely.
Now, if 300A also says it, that you cannot take away the right, save by authority of law,
Right.
wouldn't, if we put it in a converse manner, that the invocation of the order or the right under 300A has to be also conferred by way of a legal manner.
Yes. It has to be sanctioned by authority of law.
But no, not by legal manner.
Yes, in legal.
If it is by way of a legal manner,
Yes.
because the authority is there, it has been conferred by a competent authority.
Yes.
There's no quarrel with that.
Right.
So if it is it has to be a way of a legal manner. And if it is found out that later on, yes, it was a fraud being committed, so then in that case, a settlement can be kept. Because this is a new proposition which has not been there in any of the judgments. Like,
Lordship is taking a cue from Bilkis Banu because yes, correct, absolutely.
so under such
got it, yes.
circumstances, a cancellation can happen,
Absolutely.
provided the exercise of under 300A has to be also in a legal.
Rule 20.
This is a
Rule
the-
26, Lordship
But only
may
one,
give some
Mm.
but
interpretation
only
to Rule
what your
26.
lordship has said
Mm.
regarding about the manner which was given,
Mm.
the purpose for which it was given, settlement was given in a legal manner.
Mm.
But you have done some fraud in the illegal way.
No, you had the intention of having a fraud
Correct.
because
correct.
all along you have done it, showing it. In fact, that is why I asked you to read the paragraph number 6 of the last affidavit. There also you keep on repeating, yes, we have taken it. But then also your action otherwise shows no. The last affidavit, which I have asked you to
Yes.
read, you have read it now,
Yes,
paragraph number 6.
Yes.
There also you categorically say in that paragraph that we have done this for the purpose with this objective, which is similar with paragraph number
Right.
2 of the writ petition. But what you were on effect doing was wrong, was completely
No, my lord,
But only difference here, my lord, this is not been implemented.
Hmm?
It's not been implemented. Nothing has been done as
Hmm.
on date.
Hmm.
Nothing has been done. And ground reality, nothing has been done. But on facts, yes, your lordship is right. On ground, it has nothing been done. It is still empty. Even today,
no, nothing has been done. No, you have, you see, you just apply out there for a, but what you have done is you have given the right to sell to somebody. And not only to that very person now becomes the chairman.
no, that's why.
And you have filed and you have moved an application. I don't know why that was not pointed out by the revenue at the time of applying.
Yes.
When that application
Yes,
was
you are-
moved,
yes.
why the revenue or the government advocates did not point out that this is the very person who has now become the president. So the cancellation of the patta. Now what happened? You say that there is a suit filed by you for cancellation of the power of attorneys against the person now who is the chairman.
your
You see
lordship,
this judgment, it's a very beautiful judgment on this.
regarding bill.
That particular a very long judgment of 241 paragraphs. Yes. Yes, if you read this paragraph number 60 of the Supreme Court judgment,
Yes.
we have given an anxious thought to the aforesaid divergent contention. The primary question that now arises for our consideration is when is liberty of a person protected? Article 21 of the Constitution states that no person shall be deprived of his liberty except in accordance with law. Conversely, we think that a person is entitled to protection of liberty only in accordance with law. When a person's liberty cannot be violated in breach of law, can a person's liberty be protected even in the face of a breach of violation of law?
Yes.
In other words, should rule of law prevail over the personal liberty of a person or vice versa? Further, should this court weigh in favor of the person's freedom and liberty even when it is established that the same was granted in violation of law? Should the scales of justice tilt against the rule of law? So it is in that perspective this has been here. Because here, this court will be taking into account the question of a cancellation of a settlement,
Yes.
which is not otherwise there except in Rule 26.
accepting also.
So,
Yes.
if normally a settlement has been made by playing a fraud upon the authorities concerned, then in that regard, that settlement has to be held to be bad.
In fact, if my lord permits, my lord, paragraph 22 of my lord's decision in Kasha Cat Court,
Mm.
Lordship has clearly written. Moving forward, it is also pertinent to mention that when the settlement is granted in respect to a land, as has been done in the present case, a constitutional right akin to human rights accrues upon the settlement holder under Article 300A of the Constitution. This right cannot be taken away hence by authority of law. The manner in which the impugn order so-and-so was first consequently action taken on the face of it appears that the same has been done by trammeling upon the right under Article 300A of the Constitution, more so when a settlement so granted cannot be cancelled. This is important. Unless the settlement so granted was in contravention of the rules and regulations. Now, my lord,
In fact, it is not a, you may say so, this may not be a case of cancellation of a settlement. It may be a case of annulment of a settlement.
absolutely. Yes, but annulment power is there.
It may be a case of annulment of a settlement.
Annulment of the settlement.
Because here, just for example, which you people, the government advocates the government keeps on doing, as regards some persons who have been illegally appointed, fraudulent. You don't have departmental proceedings against them. Because the moment you have departmental proceedings, you'll be showing that it has been done, because departmental proceedings can be only initiated against the public servant.
Right.
So they don't do. So they keep these people out there in suspension or whatever power they do on the ground that a fraud has been committed. So they go for annulment of the entire proceeding, the selection as null and void, whereas they don't go for termination. It's not a case of termination, it's a case of annulment.
I've seen this last paragraph, which is
Yeah.
60 paragraph, beautiful reason. Last, we wish it make it clear that only when rule of law prevails will liberty and all other fundamental rights will prevail under our constitution, including right to equality and equal protection of law as enshrined in Article 14 thereof.
Mm.
In other words, whether liberty of a person would have any meaning at all under our constitution in the absence of rule of law, or the same being ignored or turned a blind eye, can rule of law surrender to liberty earned as a consequence or of its breach? Can breach of rule of law be ignored in order to protect a person's liberty that he is not expecting?
You see, the judgment, with due respect, the law is well settled by a constitution bench judgment earlier. This case, if you remember, there was a case pertaining to a person who was convicted by in the state of Madhya Pradesh. Then he was, because he was from Punjab, he went to, he requested that I should be sent to the jail at Punjab. So he was there. Now, when he was there in jail in Punjab, their rules is different for the purpose of remission compared to the rules in Madhya Pradesh. Now, in the state of Punjab, what has happened? In per the rules, he qualified for the remission and he applied for the remission. The state of Punjab granted him the remission. And then the state of Madhya Pradesh filed an application under Article 32 before the Supreme Court as to how it is possible. The matter was referred to the Constitution bench. The Constitution bench said no. It is only the state of Madhya Pradesh who had the power to grant the remission because he was convicted there. In fact, the law is this only, which has been stated out here in this judgment. So,
Only Mumbai has got the power, not the Gujarat.
Ah.
This is what it said.
so this is that
Yeah.
is that constitution bench judgment. However, in that case, there was only thing which was different is as the person who was released, the Supreme Court says that we are not interfering with that. Let him be done.
But my lord,
And here is in this case, even if the person has been released, the Supreme Court in those two paragraphs say that the right of liberty has to be also concerned.
Yeah.
While
but this fraud in the present case, let us say the fraud has been played by this to the authority. Authority, your lordship is right. Authority would have looked into it, said, no, how he can apply. He cannot apply. Rejected. Now, your lordship is going to a bigger question. Is regarding my settlement, which is cancelled, and a patta has been issued. Now, whether the settlement is for the purpose which was issued, whether it is violated, fraud has been played, then to that extent, your lordship has to enter into that area.
because
your
here is
lordship
a question
confined
of cancellation of a
Cancellation of-
settlement
settlement, and also your lordship
by executive powers.
yes, by the governor. That's what governor has given, and it has been cancelled. But what about your lordship? Then has to know the facts. Whatever the facts, how it has been applied, who has applied, power of attorney.
And by the way, in the meantime, have you got that area in operation?
No,
Till now, nothing has happened. It is still those three places:
yes.
Hatgaon, Nunmati, and Salwari.
This is also one of the area your lordship has to look into it. But now what I told, I was very frankly, why this particular person? Let me be honest to your lordship. Why this particular person you call for? He belongs to the state. Right. But why? 2017, why? This NGO is 2002. Why 2007? Apparently, it appears not only report to me also now. 2017, you have inducted a chairman. Why? Your lordship is right. As a petitioner, he comes here. What is the motive? They said very honestly. Let me tell you, Lord. They said the NGO doesn't have money to build it. Somebody we have to catch hold of a builder. Let me be very honest to your Lord. We have to have a builder. But builder doesn't mean that you what is contrary to what you are saying. Who will do it free? That's what they are saying. No one will do it. So go to the bank, take it, because for the purpose the court will not look into it. This is the whole difficulty. Only what is my prayer, as on date, it is not been set up. As on date. So, what my particular submission before Lordship is this one, that the matter keeps pending, subject to your Lordship will look into it. Keeps pending. The power of attorney which was by instrument it is cancelled. Number two, this person.
No, you have already filed a suit.
No, but if that
You have already filed a suit for cancellation.
no, but
Now
even-
that power of attorney has been already in that you filed a
no,
suit in
this person, what
2018.
I told that
After, and more particularly, interestingly, the suit has been filed in the year 2018 after they filed the affidavit on 9/2/2018.
Forest Malloy, my lord, that's what the information is has died. The Forest Malloy has died. Even then, my
No,
lord,
no, not because of that. You see the resolution. It's not because you have thrown him out on the ground of misappropriation.
yes.
That is the reason why.
But in the meantime, he is no more, my lord. But even that it can be. You go to the, it can be, my lord, power of attorney by an instrument. It goes. Nothing remains in that suit, my lord, if this is done. Second, he is removed from the, and gives an undertaking for the purpose which was given, that has to be implemented. Now, let the government take it. Your lordship, on fraud, yes, of course. I mean, I told very beginning, may have the best of best in law, but whatever the fact. That doesn't inspire, my lord. I am equally with your lordship.
No,
Only-
here
only
is
a-
another question, Mr. Das. This court will be issuing a writ in the nature of, you are asking for a writ in the nature of tertiary.
Yeah.
Now, if it is the case of a writ of tertiary, can this court now permit you to make all these amends when there are order which have been passed on the on the facts which are there, there doesn't appear to be an error, but
So, of course, my,
the
that-
judgment of Central Research Ayurvedic, where the Supreme Court says that the writ of tertiary has to be issued when there is an error which is apparent.
I am deeply obliged that your lordship has spoken of, because it should not go wrong particular in this matter. I'm extremely, my lord, sorry to say also, because law points were concentrated, but your lordship is kind enough to call us and spoken in this manner so that everything comes out. It is, I told my learned friend who has engaged, that hardly matters for me. But what is more important is what is the fact of the case.
No, I wanted to hear the reason why I'm saying it very clearly. Merely if I say that if they don't use the land, if they have not used the land for which the settlement cancellation I uphold it will open arm to the government to cancel many settlements. One has to be very careful of that.
Otherwise, my lord, my special submission is, my lord, if the practicing of fraud is writ large on the face of record, which lordship has duly noted, fraud vitiates everything. Fraud, it goes to the root of the matter. There, lordship,
Then it will be a case of annulment of a settlement.
it will
So
not
the,
be
as if the settlement which have been given becomes vitiate.
vitiates. So there is no need for taking up any exercise in pursuance of Rule 26.
No, Rule 26 does not apply.
Apply.
Rule 26, you see, kindly see another very important aspect. The power has been given to the commissioner.
Commissioner,
Now, commissioner has been defined.
Commissioner of
For
Division.
cancellation.
Yes, Commissioner.
Commissioner has been
of
defined.
Division.
Yeah.
Yes,
The commissioner has been defined somewhere.
yes, sir.
The Lower Assam Commission.
No, commissioner has been. Deputy commissioner, yeah. Because the commissioner at that point of time used to take note of many things.
My lord.
Somewhere I've seen it.
No, it is defined, my lord. Commissioner means
17.
commissioner of divisions. There,
Somewhere it is given.
my lord, I am telling.
But then also, the commissioner
My lord,
is not the government.
it is not the government.
So therefore, the commissioner will again be, in view of settlement rule number 1,
My lord,
be bound by what the government does,
government does.
by any general or special orders of the government.
Government. Government is the final authority.
Is the final authority. So the commissioner here, the commissioner has not, somewhere it is, I remember it is there. In fact, earlier it was some provincial government or all, then they made it commissioner or something.
Yes, yes. Commissioner means commissioner of division. It is there, my lord.
Deputy Commissioner defined as
No,
equivalent to
that I have seen. No, there's a commissioner
Commissioner.
also has been given. Earlier it was provincial government
My lord.
at one point of time, but that amendment happened later on, and they made it the commissioner. Anyway, okay.
Now, my lord, the office of the commissioner has also been dissolved. Lordship is aware of it. Office of the commissioner has been dissolved. Power of the commissioner has been delegated, my lord, at one point of time at a first instance to the General Administration Department, GAD. Now it has been further, my lord, revised, revisited. Now, my lord, an officer of the Revenue Department.
That one, person who is a retired IS,
Yes.
that is only for arbitration and its division. He's not for other purposes. He's only for arbitration.
No, my lord, otherwise also, my lord, the commissioner.
No,
before-
no, that communication I have to look into because that matter I'm taking it up.
No, yes. that is-
Because then I have put it before because what is the NH authority saying that you see these commissioners concerned, they are all getting the salary of the government. So you need not pay them additional for the arbitration fee. So therefore, for appointment of a arbitrator under section 3G5 of the National Highways Act, one has to, it is the commissioner of the division who were made. Now, this commissioners have been removed. Now, the problem arises as to who is going to decide this. National Highway Authority is very clear that we don't want to pay for the arbitrator. And as they are the services of the government, so they will pay. Now, the matter was referred to the GAD. And the GAD then referred it to the Revenue Department. And the Revenue Department, oh, this is a different one.
So their lordship will find three categories. The
Revenue PD transfer to the revenue.
categories of jurisdiction to be exercised.
No, therefore, no, what has happened is this arbitration of four-lane matters,
My lord,
Revenue and Disaster Management Department. Now, what they have done,
my lord.
they have given it to some secretary, chief secretary. Now, some additional chief secretary he has given, who is a retired officer. There's a by name. Huh. So he has been given. Now the question is, therefore I have put the question to him and the matter is pending. As to, in view of the mandate of 29A of the Arbitration and Conciliation Act,
My lord,
read with section 3G6
my lord.
of the National Highways Act.
Yes.
How can one person decide so many arbitration?
But I mean,
Yes.
your lordship is right.
Yes.
One,
Therefore, I have asked the Ministry of Mort to reconsider that aspect of the matter or the Revenue Department to have a call on that. And I think they are taking it and the matter is again coming up in the month of February.
Yes.
Because that is a very important aspect.
my lord, one aspect of the matter I just point out why your lordship is taking up the issue. This is very important for the High Court to remove the law defect of law. There is one special judge court. Your lordship knows there is one special judge. He's taking about 400, 500 cases.
That is
Lordship
why I'm.
Why? No, why? Because I'm very important, your lordship. I request your lordship. Why? Because your lordship knows earlier also your lordship dealt special Cortex 1950 we had. All the cases, PCI case, whether it is investigated CBI, because 1988 PCI came, then all it is in the all charge sheet was filed to special judge. Now what has happened? 1988 PCI came. Now we only the name we say the agency. Central Investigating Agency, CBI can arrest an state authority. ACB has also arrest a state employee. ACB, when he arrests, he'll produce this special judge court. CBI arrest, he puts it before the CBI. Now there is a notification of the High Court. I pointed out yesterday, 2010-11, there is a notification by the High Court, by the Chief Justice, saying the henceforth, in view of the PCI which came in 1988, these are which have been entrusted under section 3 and 4 of the PCI. It is only by that PC is income. So whatever matters have been taken by special judge court after 2011 doesn't have a jurisdiction. It doesn't have, my lord. What has jurisdiction? PMLA case. This, your lordship, highway authority.
Mr. That I am not into this criminal law.
I'm just pointing out because your lordship has
I am now onto this bench 4-5. This is a huge problem which is being faced. I've been telling them if you don't have it, it will have a cascading effect on all this litigation. There will be, and because there will be an increase of once there is an enhancement, there will be the increase with the interest. You'll have a huge problem later. And one person, I'm telling you, one person cannot.
Yes.
You have these acquisition proceedings going on in Karbi Anglong. You have it in many other places, acquisition proceedings. And whenever the national highway takes it, all acquisition proceeding, how can this one person can decide?
That's why I'm saying 1% taking about 400 cases.
Not
How is it
400.
possible?
400 is too less.
400 plus special transport.
This is not 400. This
No,
will
I'm
be
just
main.
putting an example. This is what
Anyway,
it
the hearing is
Yes.
concluded. Judgment is
deeply obliged.
I am obliged.
Deeply obliged.
eight to eight. Mure, Mure, correct. Go to Mutton Gita.
Lordship. My senior is appearing in court number 5.
Oh,
D. Sharma, Deva Sharma.
You have to dictate the order.
oh, this one.
Fine.
Let me just complete the motion first.
Two mile then.
Two, there is another matter. There's nothing to hear. I am the only
Fine,
to
fine.
pass the order. Let me complete my motion first. Motion get it. And number three. Yes, Mr. Bapuzai, what is this matter?
Then this is, my lord, this honorable court has requested, my lord, the advocate general to assist this court, my lord.
Why?
My lord, here, my lord, a writ petition has been filed, my lord, challenging judgment and conviction, my lord, passed by the special tribunal under the Land Grabbing Act.
Hmm.
Now, as on date, my lord, though, my lord, a special court has been constituted on paper, the appellate authority under section 14, but it is not
But is a
functioning.
matter moved on the 227.
Yes, now, yes, on the last occasion, my lord, on last two occasions, my lord Justice Manish Chaudhary has made a pointed query as to whether, my lord, an application under 226 would be maintainable. Because since, whether it would be writ petition criminal or it would be writ petition civil, because this writ petition has been filed, my lord, challenging
No, we'll take it
judgment
as a
of conviction.
227 proceed.
227, otherwise, yes, 227, otherwise also, my lord.
Now, in view of that judgment of the Supreme Court in the case of public premises judgment,
Yes.
wherein it has been categorically held that it may be an authority under the public, it may be a district judge, may be an authority under the appellate authority under the Public Premises Act, but then also it is an authority for which 226 jurisdiction cannot be exercised. It has to be done under 227.
227. That is one way of looking into it. My lord, another way, my lord, our respectful submission would be, since, my lord, this matter has sprang up because they are agitating a judgment of conviction, my lord, in a criminal proceeding. We take it as a criminal proceeding because,
This
my
is a
lord,
criminal proceeding.
because under the Land Grabbing Act, my lord, there are two types of proceedings has been contemplated.
Hmm.
A civil liability can be personal as well as, my lord, a criminal liability can be personal.
Now, was there civil liability initiated where both the proceedings decided together?
No.
Then how is it possible?
Yeah. Now here, my lord,
We
only
have to
that,
say that. You see, civil liability is one aspect of the matter.
yes,
Once you decide, then you have to issue notice
Yes.
as to why because then only you can initiate criminal proceedings.
Yes.
There, the yardstick would be different.
It different. Now here, my lord, admittedly, they have been convicted. Now, my lord, whether, my lord, the powers under 401 can also be applied to. Because 401 says, my lord, that this honorable court can exercise the power of appeal also. 401,
Of revision.
revision.
Why should we go for 401? This is on the face of it in violation. Can't we exercise our supervisory jurisdiction if it is absolutely, it couldn't have been done together. The act, I think section 8 of the Assam Land
Yes,
Grabbing Act
yes.
categorically mandates
Yes.
that it has to be first, you have to, 8 or 13, I forgot.
My lord,
Category,
2013, my lord, 2010 Act, Land Grabbing Act, section 8.
Civil part was cited earlier, my lord. Then criminal part started, my lord.
Civil part was decided earlier.
Yes, my lord.
Where? Then,
My lord, the judgment, my lord, which is put to challenge that your lordship will find at page 35, from page 35 onward.
since the judgment dated was passed by this court in its civil side in a public, it is public report, they with the, oh, okay. So there was a judgment initiated.
It is, it was found that part of civil liability, my lord. Then criminal part started.
So far as, my lord, the civil part is concerned, lordship will
Yeah,
find.
it has been done at paragraph 16.
Yes.
They have not challenged the order of the civil part, my lord.
Now question comes from paragraph 17 onward.
Yes. However, in the present criminal proceeding also, the complainant who adduced evidence as PW1 has written, all the PWs have been examined, my lord. And finally, my lord, the conclusion, my lord, at paragraph 23. At page 69 of the writ petition, my lord. Specified in paragraph 23, my lord. And the sentence, my lord, will find at paragraph 26 of the judgment, page 71.
Where is the petitioner? Is a stay?
Yes. Last occasion he was there. My lord, paragraph 26 is the sentence imposed, my lord. And the section 4 of, my lord, the Land Grabbing Act of 2010. So that the sentence is simple imprisonment for a period of 2 years and fine of rupees 2,000 each. Now, being accused by this, my lord, conviction, the petitioner is here before the honorable court.
But if there is no appellate authority,
Yes.
the only way out is to access to 227. There's no way out. Yes, nowhere to be seen. You want your client to be sent to the jail.
Lord,
Has he been, is he in custody? He was granted bail.
No, because this time, but no effective order has been passed.
No,
Because
no.
all
There's
these things
already,
because-
no, I don't understand. When there's a sentence, why he has not yet been arrested? Or he has to be granted on bail,
Yes.
but something or that.
Yes.
No, only lordship,
He
sir.
already undergone in judicial, if there any, during trial, shall be set off for a period. So you have already undergone 2 months or 2 years. Isn't it the strangest thing which is happening? Once a person has been convicted, either he has to be given on bail
Yes.
or he has to be saying that, okay, you are giving bail, sentenced here.
Waiting for the appellate period time, that
Huh?
3 days time that they have to file to appeal.
Where is it? There is no time for filing appeal.
Yes.
Where? When there is no appellate forum, where do you file an
Yes,
appeal?
Yeah, that is why the matter could not be heard all these days.
Anyways, we do one thing, Mr. We take it as a proceeding under 227. Issue notice and call for the record because this will be required. And
Only to that extent, Manoj, how to treat this writ petition, what would be the consequence? Only to that extent, Manoj, is court that Manoj made a pointed query. Only- because
no,
this-
the problem arises. You can't treat this as a 226
Yeah.
in view of that judgment
Yes.
on public premises.
Obviously,
This has to be taken as 227. There's no way out. Now, revisional jurisdiction can be exercised
Right.
under 397-401. by the
401.
court.
Because my lord, 401 says, my lord, in the case of any proceeding, the record of which has been called for by itself or which otherwise comes to its knowledge, the High Court may, in its discretion, exercise any of the powers conferred on a court of appeal by section 386, 389, 390, and 391, or on a court of session by section 301, 307. And when the judges composing of them, this is
The High Court will do under what provision? 386 under D.
Yeah.
These are appellate powers, or can the High Court do against any order passed in under any other act? 401? Can the High Court do?
So there has to be specific provision made under the law, specific. That
No, therefore,
category of
CRPC
appeals
concern-
will lie. Yes.
no, the problem arises. Then can the High Court do if it is not an any appeal?
Because
If,
386,
if there is an appellate forum,
my lord.
but there is no any appellate forum, yeah.
Yes.
Can the High Court exercise 401? Because that is not a concept which is taken note of by the Code of Criminal Procedure in these circumstances.
Yes. This pertains to my
It
lord.
may be a case under 482.
Yes.
The High Court can in the
Yes.
inherent order, but
Yes.
under 227. That is the only way.
Paragraph 26 of this judgment 26. Nomenclature is not a form. High Court can even convert. That is what in fact it is. Paragraph 26.
একদম ঘুরাই দিয়ক। ঘুরাই দিয়ক। I'm in your favor. I'm deciding in your favor, telling in your favor, and you're showing your judge. You see this 401
My lord.
in the case of any proceeding, the record of which have been called for by itself or which otherwise comes to its knowledge, High Court may in its discretion exercise any of the powers conferred on the Court of Appeal by section so and so, or on a sessions court under 3 when the judges composing of the revision equal. Now, therefore, these power has to be, the High Court can only exercise if there is an appellate power given to these people and these courts.
Yes. Now, my lord. Yes. Now.
So how will you imply 386,
Yes,
389?
yes, because that special court is not there. They directly jump.
Yeah.
One forum is missing.
The only way out is either 482 or
Yes,
227.
yes, that is
So we
fine.
have to do under 227 because 482 would be again the problem.
42, my lord, he will be, my lord, in a tax situation because
More
the
restricted.
scope is very limited. 482 scope is very limited.
I think this will be, I think we take it as a 227 proceed.
At least, my lord, this honorable court can appreciate the evidence on record, materials on record. That is
227, this
permitted.
can,
Yes,
court
yes.
can go into the
Otherwise,
question of paper.
482, my lord, that power is not there. My lord.
My lord. My lord, so far, day of the judgment is concerned, my lord, I submit something, my lord. Kindly see, my lord. The occasion, my lord. The petitioner, my lord, the petitioner side lost the case, my lord, defeated the trial court, then my lord, appellate court, title appeal, my
You
lord.
got the land or not? Have you got the land or not?
I purchased the land, my lord.
Have you pursuant to the civil proceedings, have you got the land or not?
No, my lord. No, my lord, decree was executed, my lord. On the very next day, then again grabbed the land, my lord.
Oh, is it?
Yeah,
The
my
title
lord.
suit was filed in the year 2006 by his vendor to get possession. Where possession prior to that, in his own admission that execution was not, that degree was not executed on the day the evidence was taken, that he himself admitted. Where long before, not on that, we enter on that day. It was a lordship, a alluvial land lordship. It could not have been settled.
My lord, in this respect, my lord,
Anyway, whatever may be, I think what is required is that we have to see it.
And he purchased
My
during
lord.
the pendenti light lordship.
my lord, I have no objection if judgment is paper, but my apprehension is that, my lord, on earlier occasion, my lord, decree was executed, my lord. On the very next day, they again dispossessed my client, my lord. Then land
No, we are going to see the sentence.
my lord.
Only sentence. Because law.
Only
he is
the
now
sentence.
basically against the sector.
Huh?
He is now basically against the sector.
Only the sentence we will see.
That is
Now, my
precisely
lord.
what my lord the prayer question.
Execution, civil liability is pending, my lord. Execution of
Let it go on. Let that go. Therefore, I'm not staying the judgment.
Judgment will not be state, only
No,
the
my lord.
sentence.
If they are outside, my lord, then they again repeat same thing. They will repeat, my lord. No, my lord. Since 2005, my lord.
Okay. Heard Mr. P. Chakraborty, the learned counsel appearing on behalf of Mr. Who appears for whom?
Respondent
On
number
behalf
two.
of the petitioner. Mr. You are appearing, Mr. Arbapudari? No, PP has to appear.
Yes, sir, yes. But we have been
Have you seen any PP around? Any PP? Wow. Give me a name of a PP.
K. Parasar, Lord.
KK Parasar. Have you seen him today? Any PP?
I'll inform him.
No. I'll have to say. Mr. M. Pupon. He's there today?
He's there, man.
Mr. M. Pupon, the learned PP. And Mr. M. Hussain,
AHMR to do.
The learned counsel appearing on behalf of the respondent number 2. So, the instant proceeding have been initiated under Article 226/227 of the Constitution, challenging the conviction of the petitioner by the special judge Hailakandi in his order dated 30/9/2023, passed in special criminal bracket LG 01/2019. This court have duly taken note of that although an appeal lies in terms with the provisions of the Assam Land Grabbing Bracket Prohibition Act 2010 against such an order, which have been assailed in the instant proceeding. However, there is no appellate authority constituted by the state of Assam. Under such circumstances, taking into account that the said order which have been impugned in the instant proceeding is an order passed by a court. This court is not inclined to exercise the jurisdiction under Article 2 to 6 of the Constitution. Therefore, the instant proceeding shall be treated as a proceedings under Article 2 to 7 of the Constitution. This court have also heard the learned counsels for the party and is of the opinion that the sentence heard the learned counsels for the party. The records pertaining to special criminal LZ case number 1/2019, more particularly the proceedings, more particularly the record, the criminal, more particularly the records pertaining the records pertaining to special criminal LZ case number 1/2019, and only the criminal, only the records which relate to the said criminal proceeding be called for by the registry. Now, this is a different number, na? The number is different.
Number is
So the
different.
entire
Number-
thing can be
number
called
is
for.
different at the time.
Yeah. The records pertaining to special criminal LG case number 01/2019 pending in the office of the Special Judge Hailakandi be called for by the registry.
Not the special tribunal.
Special
Special tribunal.
Special Judge Hailakandi. It has been said as special,
Page 45.
Sometimes special tribunal, sometimes special judge.
by the special judge pending with the special tribunal Hailakandi. Bracket additional district and session judge Hailakandi be called for by the registry of the court. This court further, in the interest of justice, stays the sentence so imposed upon the are they inside? They're not.
No.
But it's the sentence so imposed by the impugned order dated 30/9/2023 till the next day. Lists the matter again on 22/2024.
Obliged. patta land.
What?
Over the petitioner's patta land. That's the case is lordship. The petitioners are the owner and possession of their respective pattas, lordship. In which lordship they have their dwelling houses and some other lordship cattle nuts, crops and cow sheds, etc. lordship. It's a very old village, lordship, situated in village Bandukmara, lordship. A few months back, lordship,
Are you still in occupation of the land?
I am lordship. We are lordship. Yes, sir. Where they have dwelling houses also, lordship. Some of them are lordship. They are Assam type houses also, lordship. They are landlord.
Now, what is your problem?
Lordship, the respondent authority installed a signboard, lordship, and a few months back, lordship, they marked by bamboo stick, lordship, in which lordship about lordship 64 and 65 lordship the land is covered, lordship. The land is covered, lordship. 64 and 65 feet about
64 and 65?
foot, lordship, about lordship. Covered by the authority, lordship.
60
4 or 65 feet, lordship.
feet.
Feet, lordship. Feet.
Feet. They have
It is
covered.
covered, lordship.
Ah.
In which lordship they have placed a bamboo stick. If lordship the construction will be done, lordship, the petitioners will be affected.
Okay, as per the telephone instructions which I have received today morning, okay, the land acquisition process was already been overlooked. Means the land acquisition process has already been started, lordship, and the respective water resource department, when it placed the requisition before the concerned deputy commissioner, and the deputy commissioner has requisitioned the land for the water resource department, and moreover, lordship, the
Requisition. What is this requisition?
acquisition,
Acquisition. Yes.
acquisition, not
No, because water resource department has a habit of requisition.
I'm sorry.
No notification, no survey was done.
Lordship, as per my instructions, Lordship, LA estimate was already prepared and sent to the deputy revenue department, Lordship, by the deputy commissioner. As per my instruction today, which I have, and
Okay. We issue notice,
Lordship,
returnable tomorrow. Get your instruction
Lordship,
on the opening day,
tomorrow.
Look.
You have your issue notice
Look.
making it returnable tomorrow. You get your instructions only as to whether it has been done. Get me a copy of it that you have initiated acquisition.
Yes.
Once it is being done, then they will get whatever it is.
Yes.
His only worry is without an acquisition proceeding, you are going to take steps. So under such circumstances, let him also be satisfied to coming to the notice making it returnable on 12/1/2024. Mr. Arinda appears on behalf of the respondent number
exponent
1, respondent number 3 and 5. Ms. Yuda appears on behalf of the additional senior government advocate appears on behalf of the respondent number 2 and 4. And Mr. Abhacharji appears on behalf of the respondent number 1. The petitioner herein claims that they are the owners of various plots of land, wherein the respondent, Water Resource Department, as well as the district administration, are taking steps to take over the land without initiating any acquisition procedure. On the other hand, Mr. R.M. Das, the learned counsel appearing on behalf of the Water Resource Department, submits that acquisition proceeding under the Assam Land Acquisition and Acquisition Act 1964 have already been initiated, and as such, and the LA estimate has also been prepared and sent to the Water Resource Department.
sent to the revenue department by the deputy commissioner.
Sent to the Revenue Department by the Deputy Commissioner. So, taking into account the above, on the returnable date, that is tomorrow, Mr. Both the councils for the Revenue Department, the councils for the Revenue Department the district administration and the water resource part shall apprise this court with the necessary papers pertaining to the acquisition. Registry shall show the name of Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the revenue department. Mr. Doctor, yesterday's order, why it has been violated? You have informed them?
Lordship, in the meantime, Lordship, we may be protected. Otherwise, Lordship, they may touch our family land.
Till tomorrow, the respondent authority shall maintain status quo in respect to the in respect to the lands of the. Martin, yes,
The petitioner is aggrieved, your lordship, by an order that is at page 61.
oh, this one.
Lord.
I have passed an order. no?
Lordship, as first I have annexed your lordship, and your lordship, what has happened also that your lordship, this case, your lordship,
You are not a bank.
no, your lordship, we have not been a bank, we have not performed the functions of a bank. It's a credit and thrift society under a cooperative societies act, your lordship. Only thing, your lordship, the word bank is there, your lordship, but they have been, your lordship, asking us to remove that word, your lordship. What we prayed before them that your lordship, that before doing that, taking a resolution, the formal board of directors should be formed, and thereafter let the decision be taken. In the meanwhile, this order has been passed, your lordship, and your lordship will kindly, we are basically aggrieved by the last portion, your lordship. The entire bank account of these branches is now, your lordship, virtually made them inoperative.
You are not a bank.
No, we are not a bank. We are not functioning the.
Why do you want the name bank?
No, your lordship, we don't want. Ultimately, your lordship, the RDR judgment is also there. We will have to remove it, your lordship, and we will remove it, your lordship. Removing the name and your lordship, closing the your lordship, the accounts, your lordship. There is no relation, your lordship, at all.
No. If you have the bank name out there, they've been agitating out there that you should not be using the name bank.
Yes, your lordship, that's what your lordship, they have your lordship, and in fact, your lordship, although we are your lordship using, since what has happened, your lordship, this entity has a your lordship very checkered history, your lordship. Since 90s, your lordship, PILs are there, your lordship. At a particular point of time, your lordship, because of the in principle approval granted, provisional approval granted by the IBI, your lordship, this name came, your lordship. And then, your lordship, when by public notice that approval was withdrawn, your lordship, it was not stated in that public notice that you don't use the name bank. Subsequently, your lordship, this issue came. In the meanwhile, what happened, your lordship, when this initially, your lordship, the RBI issued notice and the approval was withdrawn, it created a lot of law and order problem everywhere in the state, your lordship. Because depositors became, your lordship, apprehensive. Now, your lordship, if we do it suddenly, your lordship, that may create problem. That's why the managing director, your lordship, he is praying before the cooperation department that you first hold the meeting, and then on the basis of the meeting, annual general meeting, you take a resolution and then withdraw. Ultimately, annual general meeting will have to be held, and this decision will have to be ratified by the SDM, your lordship. They are not holding.
But why is it taking from 2017? This has been taking from 2017.
That is
There was
not-
a direction by the superintendent of police PIO as to remove the name of the bank,
Yes,
and
yes.
there was a stay order obtained
Lord.
at the behest of somebody else.
Lord.
Now you are the manager.
No,
Who are
I am
you?
not the manager, your lordship. I am the
Who are you?
managing director
The Union
of
Bank.
the Union Cooperative. Now, your lordship, one-man committee is, your lordship, functioning. Their time has also been elapsed, 90 days time, your lordship. Thereafter, your lordship, I have been praying to them, we have been praying them that you hold the annual general meeting, constitute the board, and let the board take a decision, your lordship. That's what. And now, your lordship, board will take decision, your lordship. But to that, your lordship, the second part, your lordship, of your lordship, that in the interest of shareholders, it is hereby ordered that transaction in all the bank accounts. Now, daily deposits are coming, and we will have to make the depositors repayment also, your lordship, if it becomes due, your lordship. These will create lot of problems.
How are you taking a daily deposit?
Because your lordship, under the Christian society, your lordship, we are taking it, your lordship.
Now
All the members.
you have a certificate of what you call
Cooperative societies, under Cooperative Societies Act, your lordship, we have certificate of,
but you are not a bank under the
no, not a bank. It's
Then
a,
how are you receiving the money?
your lordship, as a,
You have been given permitted by the RBI.
not by the RBI, your lordship, by under the credit and tip, as a credit and tip society, your lordship, from members we can collect. And these are all members, your lordship.
So-
Only from, not from the general public, your lordship. Only from the members we are collecting these deposits, your lordship. General public, we are not going, your lordship. Only members, and those members, your lordship, will participate in the annual general meeting, your lordship, as shareholders, your lordship. That resolution was adopted in the way back in 2001 and 2002 to function as a credit and flip society, your lordship. It is a fact, your lordship, we cannot use the word bank, your lordship. In view of your lordship, what the earlier judgment also says, your lordship, of the division bench of this honorable court, your lordship.
Then why have you used it by filing the writ petition?
No, your lordship, since your lordship, for this, your lordship, we will have to amend, your lordship, everything, your lordship. An annual general meeting, resolution, your lordship, that resolution will have
So
to.
the order at page 61 seems to be very reasonable. What is wrong with the order?
Only that part, your lord.
Ah.
The last part, further in the interest of the shareholder and the depositors of the entity. It is hereby ordered that the transaction in all the bank accounts of the society being when deferments are kept in abeyance until compliance of the above.
Yes,
If
then
compliant-
only you will comply.
No, your lord, that is not,
Okay, when you can comply.
that's what your lordship I am submitting, your lordship.
You
In
submit
fact,
me a particular date when you are going to comply.
your lordship, for that, your lordship, board of directors and annual general meeting will have to be held, your lordship, board of directors.
You have been given from 2017, there is a direction. Not only that, your name has been cancelled as a bank from 2005. Then
Lordship will,
you are not doing, this doesn't inspire the confidence.
lordship, I know, your lordship, that only thing, your
This is
lordship.
this is Mr. Botago, this is not a case for issuance of a notice. if
Your
you are not
lordship will-
complying.
Your lordship will kindly
Yes, sir.
see, your lordship,
Well,
my,
lordship.
There's nothing wrong.
Yes.
Now, when your bank account has been freezed out there, then only you have woken up. Yes, you are going to.
no, your lordship will kindly
You
see.
comply. And they have not done it. They say that, okay, you remove the bank, then you can very well do it. Why you are not doing?
Your lordship, this is because your lordship, what if they constitute it, and your lordship will kindly see the, here is what it says.
I think a division bench may accept your notice.
Lordship
And
will
for
kindly
that, I
see,
should pave the path for you to go to the division.
no, your lordship will kindly see,
The lordship
Ultimate-
order is very specific in page
Yeah,
49.
that's in it.
only,
Yes, my
only thing, your lordship,
No, Mr.
ultimately,
Vatrapal.
this
Yes.
decision will have to be taken by
I
the,
think only the division bench or the
Yes.
Supreme Court may be very kind enough.
no, your lordship will kindly see that unless the body is constituted.
I can only help you.
In that regard. Only issue, your lordship, is that, and in fact, we have filed a petition, your lordship, writ petition, your lordship, which is pending, seeking a direction to hold the annual general meeting so that board of directors can take over the functioning, and then, your lordship, they will take a call. I am only a managing director. There is one man committee functioning. Even for that, your lordship,
It's done by one man committee,
Yes,
by
your
the government.
government, your lordship.
If the lordship may direct the one-man committee to hold the AGM, SDL.
Yes, your lordship, and take
Can
it
the
down.
one man committee hold the AGM? He
Election.
can only hold the AGM.
Yes.
And who one man committee will be your person.
Be our officer.
When are you going to hold it?
That instruction I don't have. It's
We'll have it tomorrow. Get
Sure.
your instruction.
my
Lord,
Let the matter tomorrow.
lord.
Obliged,
deeply obliged.
obliged.
Timing item 2.
And madam, also find out tomorrow one thing. Can the name which have the authorities have categorically mentioned
Right.
to remove
Sure.
from 2005, can it be removed at the behest of any other manner in terms with the corporate side?
Lordship.
Just find
Section 8 is also there, lordship.
whatever may be.
My lord.
Can a name be removed just for the by on the basis of the directions being passed by the
Sure.
just for example, yes, the name is Union Cooperative Bank Limited.
Okay.
2005, the Reserve Bank has cancelled their license.
Sure.
And they were not allowed to use. Then there have been various directions being passed to remove them, which
Sure.
they have not. They have filed a writ petition to the Managers Association for removing that. That I had dismissed it on the ground that when the bank is not agreed by the decision
Sure.
of removing the bank's name,
Sure.
then who are you?
My lord.
For which I have dismissed it.
Sure.
Then the matter has come again. For that, this impugned order has been passed.
My lord.
Now, therefore, the question is, can by any other move, apart from the ATM,
Sure.
the name of the bank get
Lordship. I will get it short. My lord.
Obliged,
In the lordship, in the PI lordship, there is a direction to the register to the needful. Page 77 of the writ petition.
I have annexed that order. And I
there is a
have
direction to the register to
To do the needful.
to cause an inquiry, your lordship.
cause an inquiry. No. Can the name? This is a
Sure.
very pertinent question.
My lord.
Then whether an authority under the Assam Cooperative Societies Act direct or direct and remove without the ATM.
My lord.
Because the ATM is the question. He's
Right.
taking the help of the ATM.
AGM.
So
Lordship.
just find out.
My
And
lord.
as it is under proceedings is under 41(6),
41.
so therefore it has to be done by
One
the year person. Now,
Right.
if it is under year, who has filed the writ petition? Who has filed the writ
I am the managing director.
Managing director.
Managing director.
No, once it has been taken over, is there any managing director?
Yes, your lordship.
It is the MD is the separate
It
authority.
is on a
lordship.
separate level.
My lord. And the board of directors is
The
something else.
society will be.
My lord. I will get those instructions,
Yeah.
lordship.
deeply obliged, my
Obliged.
lord.
The instant writ petition heard Mr. So the learned counsel appearing on behalf of the petitioner, Mr.
D. Sharma, Deva Sharma.
Madam, you are appearing for the respondent,
My lord.
H.
The time
Sharma.
of hearing is
H. Sharma,
my lord.
he's
His name
there.
is- His name is
Mrs. Udas, the learned additional, Mrs. Udas and Mr. H. The learned counsel appears on behalf of the respondent 1 to 4. And Mr. Sharma
D. Sharma, Deva Sharma.
appears on behalf of the respondent number 5. The instant writ petition has been filed by the petitioner being aggrieved by the actions of the respondent authorities to settle the number 22 Laipulia Min Mohot with the respondent number 5 by the impugned order dated 19/5/2020 and have also further sought for a direction that the said Mahal be settled in favor of the petitioner society. The facts which can be discerned, the facts which can be discerned from a perusal of the pleading is that the petitioner herein is the secretary of a society in the name and style of MS Bohaigaon Bohumukhia Mohila SS Limited. A notice inviting tender number DRF.8 oblique PT Roman 2 oblique 2014-15 oblique 57 dated 23/10/2019 was issued by the Additional Deputy Commissioner Revenue Dhemaji by inviting applications for settlement of various fisheries, including number 22 Laipulia, Mean Mohol, for short, for the sake of convenience, referred to as the fishery in question. In pursuance to the said notice inviting tender, the petitioner, along with various other bidders, had duly participated in the said tender process. Before proceeding further, this court finds it relevant to take note of some of the conditions of the notice inviting tender. From a perusal of the said notice inviting tender, it reveals that the public in general were informed about the bid documents, and in addition to various conditions, the PAN card issued by the Income Tax Department in the name of the cooperative society, oblique the self-help group, oblique NGO have also to be submitted. It was made clear that a PAN card issued in the name of any office bearer cannot be deposited. Amongst the various conditions which have been stipulated in the said notice inviting tender, it has been mentioned that a certificate of 100% fishermen has to be issued, a certificate of 100% fishermen issued by the Assistant Register of Cooperative Society, bracket ARCS, bracket to the Fishermen Cooperative Society, comma, self-help group or the NGO should be submitted along with the tender application. It was mentioned that the members of the tendering Fishermen Cooperative Society, comma, self-help group or NGO must be of the scheduled caste community or Maimal community of Kachar district of erstwhile Assam should be mentioned in the said certificate issued by the ARCS. This court also finds that apart from the said 100% fishermen society certificate, there is a requirement of submission of a neighborhood certificate issued by the concerned revenue circle officer to the Fishermen Cooperative Society, comma, self-help group, comma, NGO, with clear indication of specific distance of the Fishermen Cooperative Society, comma, self-help group, comma, NGO to the concerned fishery, along with their bids. In terms with clause 3, the fisherman experience certificate has also to be submitted, issued by the district fishery development officer to the Fishermen Cooperative Society, comma, self-help group, comma, NGO, indicating that all the members of the Fishermen Cooperative Society, comma, self-help group, comma, NGOs have ample experience in fishing and related activities, and they are fully involved in such activities. There are various other conditions which, however, being not so pertinent for the purpose of disposal of the instant writ petition, this court, for the sake of brevity, is not referring to the same. Be it as it may, the record reveals that in respect to the fishery in question, as many as 5 bidders duly submitted their bids. Amongst the 5 bidders, the petitioner is one petitioner and the respondent number 5 were amongst the 5 bidders. Of these 5 bidders, the bid submitted by the Laipulia Anusutita Jati Min Unayanan Committee has submitted, 5 bidders have duly submitted. The record reveals that in the minutes of the tender advisory committee meeting held on 29/11/2019, it was opined that the other 3 bidders, other than the petitioner and the respondent number 6, other than the petitioner and the respondent number 5,
Yes, sir.
did not submit various documents. However, as regards the respondent number 5, it was mentioned that the 100% actual fisherman certificate by the ARCS was not submitted. In the case of the petitioner, it was opined that the documents which were submitted were in order. So accordingly, the tender advisory committee recommended that the tender of the petitioner for settlement tender of the petitioner. Had recommended the tender of the petitioner for settlement and to forward all tender papers and documents to the government for further necessary action. The record reveals that thereupon the petitioner filed a writ petition before this court, which was registered and numbered as WPC number 1619/2020. The said writ petition was filed by the petitioner being aggrieved by the action of the respondent authorities in not granting the settlement to the petitioner, in spite of the fact that the tender advisory committee had recommended the settlement to be made in favor of the petitioner. When the matter was taken up on 4/3/2020, this court directed the matter to be again listed on 23/2020. And in the meantime, directed the respondent authorities to obtain instruction. However, while the said petition was pending, on 19/5/2020, an order was passed whereby the fishery in question was settled with the respondent number 5 on the ground that the respondent number 5 had quoted rupees 10,99,007 for 7 years, which was the third highest, whereas the petitioner quoted 8,47,000 for 7 years, which was the fifth highest. It was also mentioned that from the scrutiny of documents, it revealed that the respondent number 5 is in the neighborhood of the fishery in question within 300 meters than the petitioner, which is located at a distance of 9 kilometers from the fishery, for which the bid of the respondent number 5 was more acceptable with a higher bid, as well as the neighborhood of the fishery, which is in conformity with Rule 12 of the Assam Fishery Rules 1953. This court also finds it pertinent to take note of the order dated 19/5/2020, whereby the authority concerned have also duly taken note of that the respondent number 5, which is a self-help group, had not furnished the 100% actual fisherman certificate issued by the ARCS Demaji in terms with clause 1 of the NIT. It was also mentioned that the respondent number 5 had furnished a certificate issued by the DFDO, Dhemaji, which covers both as 100% actual fisherman certificate as well as the experience certificate, which was accepted. As regards the petitioner, it was mentioned that the experience certificate issued by the DFDO, Dhemaji, had not specifically mentioned the word experience, although from the activities described in the certificate, it can be construed as the experience certificate. It was also mentioned that as per the report of the circle officer, the petitioner society was located at a distance of 9 kilometers from the fishery. Petitioner, therefore, being aggrieved by the order dated 19/5/2020, has approached this court by filing the present petition. The record reveals that this court, by an order dated 15/6/2020, issued notice making it returnable by 4 weeks. Thereafter, be that as it may, it is relevant to take note of that there was no interim order passed against there is no order passed staying the order dated 19/5/2020. The record further reveals that an affidavit in opposition was filed by the respondent number 1. Who has filed? Government has filed an affidavit in opposition has been filed by the respondent number 1 on 13th of June 2022. From a perusal of the said affidavit in opposition, it revealed that the tender documents of each of the 5 bidders were examined, and the authorities in the government was of the view that the bid offered by the respondent number 5 was in order, and his bid was higher above the rate quoted by the petitioner society. It was stated that as regards the objection against one of the documents submitted by the respondent society, the government considered the certificate issued by the DFDO, Dhemaji, to be the experienced and 100% actual fishermen of the SC community as valid, as the respondent is registered as a Pathar Porisolana committee under the Agricultural Department, and because of that, the 100% actual fisherman certificate was not issued by the ARCS on the ground that the Pathar Porisolana committee is not registered under it. It is also stated that the authorities in the government also have taken into consideration the neighborhood issue in terms with Rule 12 of the Assam Fishery Rules 1953, bracket as amended, as the members of the respondent number 5 reside within the neighborhood of the fishery, and that too within a radius of 300 meters, whereas the members of the petitioner society reside at a distance of 9 kilometers from the fishery. Further to that, it was also stated that the certificate submitted by the petitioner along with the bid was without the word experience, but was accepted by the authority as the contents of the certificate construed to be experience certificate. It was stated that among the two valid bids, the bid offered by the respondent number 5 was higher than the bid of the petitioner society, and that part, the members of the respondent society was in the immediate neighborhood of the fishery, residing within a radius of 300 meters only, whereas the members of the petitioner society reside at a distance of 9 kilometers from the fishery. This court have also duly taken note of the affidavit in opposition filed by the respondent number 5. What is this certificate of this you have got under the Right to Information Act? What is this paragraph 6? Of your affidavit? And para 6, page 16 of your affidavit has been unauthorized issue. What is language?
Lordship, this RTI application has been filed regarding the committee of the petitioner has been constituted with more than the numbers which is mentioned in the certificate, Lordship. The general member, they have not disclosed in the certificate. They are not 100% fishermen, otherwise.
Why?
Lordship, I have, because Lordship, the member, total member is Lordship, more than the number prescribed in the certificate. Lordship.
And total members are what? Clearly indicate that
286.
there are 286.
Yes, sir.
Where are you getting 280?
Lordship, I have enclosed that this is the document that has been furnished by the.
But there are 282.
Yes, sir, Lordship, that's right.
Then
They have
282.
not disclosed 286. The remaining members are general members, not the 100% fishermen.
Why are you saying
Lordship,
what they have disclosed?
Lordship, this certificate itself disclose that they have only 282 members.
Ah.
But the document which has been furnished by the Assistant Registrar of Cooperative Societies, Lordship, they are disclosed that their total member is 286 members. That's why I have enclosed this.
How are you saying from here?
Lordship, this is the document furnished by the Lordship ARCS.
No, where is it mentioned that they are not? They are general members. How are you saying?
Lordship, I have only said that, Lordship, they have not disclosed all the members. Lordship.
How many members they have?
They have disclosed, Lordship, in their certificate 282 members.
Then
And total 82, but total member is 286.
where is it?
Lordship, in the document which has been furnished, Lordship.
Now, who are the general members?
Lordship, apart from that, whether these are the general member or not, and I have not given any statement
Then
regarding this.
why you are making all these things unnecessary? This court have also perused the said affidavit in opposition filed by the respondent number 5, which is also in parameteria with the affidavit filed by the respondent number 1, for which the petitioner, for which this court, for the sake of, for avoiding prolixity, is not repeating the same. The record, however, reveals that there has been no replies filed to the affidavit in opposition filed by by the state respondent as well as the respondent number 5. I've heard the learned counsel appearing on behalf of the petitioner as well as the state as well as the respondent. From hearing the learned counsel for the respondent, the issue arises as to whether the respondent, the point for determination which arises for decision is whether the respondent authority could have granted the settlement in favor of the respondent number 5 by the impugned order dated 19/5/2020 without the submission of the 100% fisherman certificate issued by the Assistant Register of Cooperative Society. That is the only issue. That is the as to whether settlement could have been given to them without the 100% fisherman certificate issued by the Assistant Register of Cooperative. That is it. That is the issue. No, not that is not there. You want the settlement also. The second issue which arises is as to whether if the settlement granted in favor of the petition, respondent number 5 is set aside, can this court direct granting of settlement in favor of the petition? Take on now. This certificate is issued by the ARCS under what provision? No, Econ Cooperative Society. This court have duly taken note of Rule 12 of the Assam Fishery Rules 1953, for short, the rules. In terms with Rule 12, it is stipulated that except those referred in Subrule 8B, all registered fisheries shall be settled under the tender system of sale in place of sale auction. It further stipulates that the government shall settle 60% category fishery with special categories of cooperative societies, non-governmental organizations and self-help groups consisting of 100% actual fishermen in the neighborhood of the fishery concerned by the tender system. The explanation 1 to section 12, rule 12 stipulate that the word special category means and includes cooperative societies, self-help groups, non-governmental organizations comprising of 100% actual fishermen of the scheduled caste community or Maimal community of the erstwhile Kachar district, who cannot participate in competitive bidding because of poor financial condition due to famine, flood, drought, epidemic, of any other circumstances which are beyond the control of the society, non-governmental organization or self-help groups as the case may be. Therefore, from the above rule, it is made clear that the society, that settlement of the 60% category fishery can be made upon cooperative societies, non-government organizations and self-help groups. Now the question therefore arises as to whether the assistant register of cooperative society would have the power or authority to issue a 100% fisherman certificate to a non-governmental organization and or a self-help group. This court at this stage finds it relevant to take note of the Assam Cooperative Societies Act 2007, for short, the Act of 2007, which is an act to consolidate and amend the law relating to cooperative societies in the state of Assam to facilitate the voluntary formation and democratic functioning of the cooperative society as people's institution based on self-help and mutual aid, and to enable them to promote their economic and social betterment. Section 2J defines the term cooperative society or the society to mean a cooperative society registered under the Act of 2007 and includes a society formed after amalgamation of such two or more societies or by division of an existing society. This court further finds it relevant to take note of Section 3 of the Act of 2007, which stipulates that the state government may appoint an officer to be the register of cooperative societies for the state or any portion of it for the registration, supervision, assistance council and for the all-round development of the cooperative movement in the state with such other powers and responsibilities as may be provided under the Act of 2007 or the rules or the bylaws framed therein under. Subsection 2 of Section 3 stipulates that the state government may also appoint any other person or persons to assist the register and may by general or special order in writing delegate to any such person or persons all or any of the powers and responsibilities of the register under the Act of 2007. Therefore, from a perusal of Section 3, it would be clear that the power to be exercised by the register of cooperative societies or any person appointed to assist the register of the cooperative societies would only be in relation to a cooperative society. This court have also put a query upon Mrs. U. Das, the learned additional senior government advocate, as to whether any power has been granted to the assistant register of cooperative societies or even to the register of cooperative societies to give certification in respect of any other groups of persons or associations who do not come within the ambit of cooperative society as defined in Section 2J of the Act of 2007. Yes, madam.
That cooperative society, that because it's Planished one method.
It cannot.
But-
Can it? Is the Barbudari? It
Yes.
cannot.
Cannot.
It has no authority.
Yes.
Mrs. Yudas, the learned additional senior government advocate, submits that from a perusal of the Act of 2007, there is no power which have been given by the respondent by the said Act upon the register of cooperative society or any other person appointed to assist the register of cooperative society by the Act of 2007 to give a certificate to any other association, societies, group of persons other than those which falls within the ambit of cooperative societies as defined in Section 2J of the Act of 2007. In the backdrop of the above analysis, the question therefore arises as to whether a cooperative society, as to whether the petitioner number, the respondent number 5, who admittedly is not a cooperative society, can be issued a certificate by the Assistant Register of Cooperative Society. This court have duly taken note of that in the impugned order dated 19/5/2020, the tendering authority have duly taken note of that the respondent number 5 is a Pathar Porisolona Committee, which is registered under the District Agricultural Officer, Dhemaji. And in the affidavit which have been filed by the respondent number 1, it was also categorically mentioned that a Pathar Porisolona Committee cannot be granted a registration certificate, granted any certificate by the Assistant Register of Cooperative Society. The consequential question, therefore, is as to whether the respondent authorities were justified in not and were justified in disregarding the non-submission of the assistant register of non-submission of the 100% fisherman certificate by the respondent number 5. From the assistant register of cooperative society. This court have duly taken note of that as per Rule 12 of the fishery rules, it is clear that the settlement can be made in favor of cooperative societies, self-help groups, as well as NGOs. The self-help groups as well as the NGOs cannot be issued a certificate by the self-help groups as well as the NGOs cannot apply for a certificate from the assistant register of cooperative societies, as if they don't come within the ambit of Section 2J of the Act of 2007. This court have also duly taken note of that in the tender document, it has been categorically mentioned that not only a cooperative society, a self-help group as well as a non-governmental organization can also apply. Under such circumstances, in the opinion of this court, as the respondent number 7 was not in a position to obtain the certificate, which the respondent authorities and more particularly the tendering authority knew, and thereby have waived the said condition by specifically taking note of that the fisherman certificate given by the DFDO was in compliance to the requirements. This court is of the opinion that the said action on the part of the respondent authorities can, in passing the impugned order dated 19/5/2020, cannot be interfered with. This court also finds it very pertinent to take note of that not only the respondent number 5 had quoted a higher amount, but the respondent number 5 also resides within an area radius of 300 meters from the fishery in question, which is a finding of fact, whereas the petitioner herein, who had whose location is at a distance of 9 kilometers from the fishery in question. This also is in consonance with Rule 12 of the fishery rules of the rules of 1953. Under such circumstances, this court finds no merit in the instant writ petition, for which the same stands dismissed.
Respondent number 5, in case of respondent number 7,
Anyway, he knows.
highly blessed.
Mr. Khan is experienced.
Madam, you can also decide, my lord, if the tender consent is bad, my lord, then the consequence of this tender
তাৰপিছত আৰু এটা তাৰ ওপৰতে লিখিব হা। In view of the above analysis in respect to point for termination number 1, the second point for determination does not arise. Accordingly, this court does not find any merit in the writ petition for which the same stands.
highly
Lord, on the last occasion, my lord, we were directed to file affidavit, my lord. And the last chance was given to us, my lord. I could not file the affidavit, my lord. I pray for some time, my lord. At least 4 weeks time, maybe granted, my lord.
You are
I'm appealing for the Union of India.
Union of India.
Yes.
Very well. Union of India. Pay some cost. 2015 matter.
Yes. In fact, my lord, what happened, my lord, I didn't communicate, to be fair and honest, my lord, I didn't communicate to them, my lord, because I was under the
Okay, the
impression,
cost will be beared by you.
that is the fact, my lord. I only communicated on the last date, my lord, and they say they have paid for some time.
His appearance cost. 55,000? 55,000 is,
I'm not in a position to pay that
No,
much.
no. then we'll initiate
In-
proceedings for sale of your property. Can't help it, it's a 2015 matter, it is
Yes,
very,
yes, absolutely,
this
sir.
court has
I-
categorically mentioned.
Yes.
The record reveals that on various occasions, the Industries Department as well as the Union of India has fought for time for filing the affidavit, but till date the affidavits have not been filed. This court makes it clear that if the industry as well as the state of Assam and the Union of India do not file the affidavit on or before remand, this court shall dispose of the petition on the basis of the materials available on record.
Only
We
one
will
thing, sir,
dispose it on the
Yes.
basis of the materials.
but only one thing, my lord, on the various dates, my lord, I did not wait for time because I was under impression, my lord, that they would find. Because here, my lord, is a policy
This
framed by
court
us.
made it very clear.
Yes.
Is your name Mr. M.R.
Madam,
Adhikari?
madam,
Your
madam.
name glaringly appears in the order.
Yes, my lord, on the last date, my lord,
Enough.
I was there.
Matter is enough. You have not filed.
Yes.
Yes, what is your case?
Well, my case is, my lord, it is by capital investment subsidy, under 2007 scheme, my lord.
Yours, what subsidy?
Central Capital Investment Subsidy. Scheme is at page 26, channel 29 is a Central Capital Investment Scheme. That's very cheap.
Where? 20, the capital investment?
Yes.
Okay,
Page
29.
29 at page
Or
30.
this notification has been issued here.
Page
The
30, my
scheme
lord.
has
your
been
lordship,
called the Central Capital Investment Subsidy Scheme. Ima.
Page 30, my lord. Scheme number 6, my lord. Plant and machinery for manufacturing sector, my lord. That has been defined, my lord. In calculating value of the plant machinery, cost of industrial plant machinery, my lord, these things are there. Now, under this, my lord, operational guidelines has been also issued, which is at, my lord, page 34, 7. My lord, 36 and page 37, if you have see, my lord, page 30,
37.
37, at page, my lord, 41, my lord, the details have been given. Fixed, what is fixed capital? The last, that has been
Where
given,
the
my lord.
factory building has been constructed and you show a permission for construction from the local authority. Okay, now what do
Now,
you
my
want?
lord, under this, my lord, I have applied, I was registered, my lord.
When did you apply?
My registration was granted on 27/10/2009, 56 page.
Huh?
Page 56.
Certificate for registration. Central Capital Investment Subsidy, Central Demand, Interest Subsidy, Central Comprehensive Insurance. Now, have you got the other two?
Hello?
Have you got the Central Interest Subsidy?
That, my lord, I not know, my lord.
Okay,
That is
very well. Nile?
Now, I have applied for the, my lord, because my yeah, production started, my lord, 25/11/2011. At page 80, my lord, you'll also find.
You've gone for commercial production.
Yes.
On
25/11/2011. This is the acknowledgement, my lord. Yes, they have said that date of production is 25/11/2011.
then
Then I have submitted the claim, my claim, my lord.
where? This one.
This
81.
81. My lord,
How much
my
you are asking?
investment was shown at page 79, my lord. 120 crore and all.
1 crore, 120 crores, 35 lakhs, 57,790. Entire amount will be paid.
No. But
How much?
30%.
Huh?
Now 30%.
Okay.
Now, my lord, my claim was forwarded at page 88, my lord, by the general manager. He has reduced, my lord.
Okay. So 22.
22, my lord, is the capital investment.
Then
Now, they have given the page 89, 14 crore and all.
Okay.
On the basis of the, my lord, the subsequent operational guidelines in 2013, which is not applicable.
Why?
My lord, 2013 guideline, my lord, because I have already, my lord, installed the plant and machinery and my production has been started in 2011.
operation guideline 7 will apply.
Where is the 13?
13 is at page, my lord, 94. Here, my lord,
Why they have reduced?
my lord,
13 is what?
guideline is at page 90, and this is the, my lord, eligibility component. Yeah.
Where?
94.
54.
Yes.
Now what has happened? They have amended.
Yes, there.
30.
The last para, my lord, para 4. Now at page, my lord, 95, you will also find some of the, my lord, has been excluded.
What?
A component.
Loading and unloading charges. Dead building for plant and machinery.
Yes, my lord, these are
Miscellaneous fixed assets such as DG, excavation. Earlier it was included.
my lord, yes. Your lordship, my lord, the page 90, 41, my lord.
You want. Okay. We are coming. 2 o'clock. Now, as per your scheme earlier,
Yes.
in what are the things you are going to get?
My lord, the building plant, the building plant, my lord, these are land, these are there. And
Where?
these are now,
Where? Where is it mentioned?
my lord, that here, lordship, you will find page 79.
Hmm?
Page 79. That's the certificate of that.
No, this is your document. I'm not saying that. They are saying that they are going to give to you all these things which have been now not taken into consideration.
They have not stated that, my lord.
So if they have
Because your
not
lordship will
stated
see-
that,
Your lordship will see that page 88, the general manager
Hmm.
has calculated 30% CCIS.
that might be wrongly he must have done. But what is the basis of this calculation of 22 crores? You have to show that from these earlier which have been given as per the industrial policy resolution as well as the schemes which have been issued,
Well,
that you are entitled to these which have not been has been taken away in 2013.
But we have calculated, and as per the calculation, we find that these things are.
Because as per your calculation which you have given at page 80
Yes.
and 79,
Done that.
it is some 1 crore 20.
20.
But here they have found out as 74.
70.
So under such circumstances, how are you saying that these particular portion have been not taken, some portion has not been taken away? What is your basis?
That is, my lord, that is what we have calculated, my lord.
You have calculated a different thing. Your calculation has not been even taken into consideration. Your calculation is 120 crores. They have taken only 74, and of which they have, he has said 30% is this. Now they have reduced it.
Yes.
So earlier, you were entitled to, just for example, You are entitled to loading and unloading charges, sheds, buildings for plant and machineries, commissioning costs, captive power plants. All these things you are entitled to is where it is given.
My lord, if your lordship see page 79, my lord,
Yes. No,
page 79, item
no,
number.
this is your document.
No, correct, my lord. What is considered by the general manager?
Hmm.
4, 5, 6. My lord. These are the 3 items, my lord.
4,
5, 6.
5 is 0,
4, 5, 6. 5 is not there. 4,
6 is 10 lakhs,
10,
10
crores.
crores.
10.
So these 10 crores have been taken, electrical installation.
Yes.
Now, what is this form of electrical installations which are there as by Annexure B? You have not enclosed.
It has not been closed.
Then-
No, this was considered by the general manager. My lord.
Oh, general manager may not be the authority whether these things were to be taken or not. Has to be whether you were entitled to these amounts or not. You have to show that yes, earlier in 2011 till 2013, you were entitled to these things which have now been excluded in 2013. And as such, as this has been excluded, your right had accrued earlier on the basis thereof. Or even in that particular, this is the enquiry report. Enquiry report also would not show. Kindly come to the notification of the Central Investment Subsidy. This is the notification of 27th of July 2007.
Yes.
Out there, which are the things which are there?
Yes.
Scheme shall not be applicable to industries of so and so. Then definition extend plant and machinery for manufacturing sector. In calculating the fact that the cost of the industrial plant and machineries as erected at the site will be taken into account, which will include the cost of productive area, such as tools, jigs, so and so. Insurance, where the amount invested in the goods carrier to the extent that they are actually utilized for the transport of raw materials and marketing of. This is the transport subsidy as well. Working capital including
No, transport subsidy is not the transport subsidy. Transport subsidy is for the what was the running. First profit.
working capital including raw materials and others will be excluded from computing the value of plant and machinery.
Yes.
This is also there earlier.
Yes.
And now, kindly come to page 95. This has been excluded in number 4.
Well.
Now kindly come to page 95. Roman 4. Freight charges paid in bringing the plant and machinery and equipments from the supplier's premises to the location, that is included, which is number 6, Roman 2. So, no case.
No, my lord.
No case. No case.
Just my lord, your. No, my lord. This has been considered, my lord. Your lordship see, these are the 2 items which has been considered. Plant machinery, including loading, unloading, transportation, my lord, that is page 79. And electrical installation. These are 2 items, my lord, which has been considered by the CM.
Where it has been said out here, electrical accident, loading and unloading charges.
Yes.
That is not there as per this notification.
But they have to clarify it, my lord. Which how
No,
they,
here it is given 6, 1, 2, 1, 2, and 3. You have to therefore demonstrate
Yes.
that 6, 1, 2, and 3 include something which have now been excluded out here in page 95B. Then only you will have some case of promissory estoppel.
my lord, what I am submitting,
Yeah.
general manager has included these 2 items.
Forget about general manager, whatever he does. I'm not on that.
Yes.
I'm How do you know that the general manager, he has also not mentioned anything?
My lord, because he has given the, as per they have, my lord, the, committee, he has mentioned it, but not to us. We have
Yeah.
been given only this, one.
So,
So,
I'm
they,
confused.
without finding the affidavit, my lord, how it can be said, my lord, that what has been excluded? My lord, because out of these, my lord, these two items are included.
Which two?
The page 79, item number 4 and 6.
Okay, let us assume that the general manager have included loading and unloading charges.
Yes.
And which one?
And electrical, this one.
Electrical is where? Electrical is already there.
Yes.
Electrical components necessary for plant and operation is already there. It is included.
Yes.
In 8 Roman 3.
No, electrical installation is not there, my lord.
No, electrical components necessary for plant and machinery in the plant site for the where the meter is installed and to the point of finished goods, motors, HT motors, LT motors, switchboards, panels, captivators, relay, circuit breakers, panels, switch gears, all these are there. These are part of it.
They're under the electrical installation.
Yes, that is what, this is already included.
No. No, if you, my lord, how they can reduce it, my lord, that thing, my lord, they have to,
Which they have reduced it.
they have to explain, my lord.
Now,
Because-
this reducing out there is 10 crores, 5 lakhs. Isn't it?
My lord,
10 crores, 5 lakhs is the electrical incident
Yes.
which have been reduced.
no, I do not know, my lord, that what has been,
Now, that may have been reduced even by the general manager. How
No.
do you know?
this we have clarified, my lord, they are, that is why I am noted down. That these two things have been added, that is why he has come to 74 lakh. If your losses add, my lord, these two items only, then gentlemen just, come.
Add to what?
This, item number 4 and 6,
4 and 6.
Six.
Then it is 83 crores.
my lord,
That is 83 crores, 30,
My lord.
39 lakhs. But the general manager has come to 74 crores.
he might have today some. So, out of these, my lord, it cannot be assessed, my lord. What calculation has been done, my lord, that is the main question.
Your calculation, you want as per page 79.
I want, my lord, as per page 88.
88. No, 88, how do you, is the general
plant
manager the
machinery-
final authority?
Including electrical installation, sir.
No, here he said plant and manager including electrical installation, he has come to 74.
Yes, yes.
Now, if we see as per your certificate, the cost of plant and machinery including loading, unloading, transportation, erection, expenditure and insurance, etc. as per Annexure A.
Yes.
Now, interestingly, you have not enclosed the Annexure A. Why? You have not enclosed the Annexure B. Why? And the matter has been pending from 2005. And you want this court to make a roving and inquiry
No, my lord, at least, my lord,
or make you get your evidence.
no, they can
on your
clarify, my
behalf.
lord, how they have calculated it.
How they have calculated? Is it your case out here? How they have calculated? Your calculation is that now they have giving it out their certificate of registration and now coming to commercial production.
So,
Yes,
if-
so and so
If
towards
it is
plant and
cost of
demand.
plant and machinery
Yes,
there, my
yes,
lord, this general manager has given the cost of plant and machinery including electrical installation. It's the only what general manager has given.
yes.
How they have reduced it, my lord, so much? Only 42, 43 crore. 30 crore has been reduced, my lord. Like to investment has been reduced to 30.
The court have heard the learned senior counsel for the petition at length. Upon hearing, transpired that the petitioner have claimed an amount of rupees 83 crores 39 lakh 85,772 as eligible investment in for plants and machinery, including in electrical investments. It further transpired that the general manager District Industries and Commerce Center had reduced the eligible investment on plant and machinery, including electrical installation, etc., to rupees 74 crore 93 lakh 23,430. Taking into account the above, the total entitlement of the petitioners to the petitioner on account of subsidy in terms with the Central Capital Investment Subsidy Scheme 2007, it was adjudged as rupees 22 crores 47 lakhs 97,030. However, on 7/7/2014, an amount of rupees 14 crores 87 lakhs 68,200 has been sanctioned as Central Capital Investment Subsidy Scheme. It is the case of the petitioner that the said reduction on the eligible investment made by the petitioner by both the general manager, District Industry Center, as well as the SLEC,
This effort to be
as well as the empowered committee
effective.
of the Union of India is without any basis, as there has been no justification given by the said respondent authorities in their calculations, so provided by the annexure Roman 19 and Roman 20. This court also has found out, and this court has also taken note of, that in spite of the fact that the instant writ petition has been pending since 2015, the respondent authorities, for reasons best known, have not cared to file any affidavit clarifying their stand in the writ petition. This court further observes that by order dated 21/12/2023, it was made clear that if the Industries and Commerce Department, State of Assam, and the Union of India does not file the affidavit on or before 8/1/2024, this court shall dispose of the instant writ petition on the basis of the materials available on record. It is, however, relevant, in spite of the said directions being given, then also both the State of Assam as well as the Union of India have not filed their affidavit in opposition, clarifying the above stand. The money which is to be disbursed to the petitioner is public money, and the respondent authority ought to have been more careful in not in in allowing the instant proceeding to proceed in the proceed without traversing to the facts alleged in the writ petition. It seems the respondent authority, more particularly the Industries Department of the Government of Assam, who have been given the responsibility for the purpose of adjudicating, for the purpose of making for certification on the eligible investment, as well as the Union of India Empowered Committee, is not at all bothered with as to how the public money is to be expended. Because under such circumstances, this court fixes the matter again for further consideration on 24th of January 2020, 25th of January 2024 for further consideration. A final opportunity is given to the respondents to provide the necessary clarification to the above queries, and failing which it shall be assumed that the respondent authority have incorrectly disregarded the eligible investment as stated in the writ petition. Full stop. In such circumstances, this court may also pass appropriate directions against the respondent authorities for in such circumstances, this court may also pass appropriate directions against the respondent authorities to take appropriate action upon the erring officials in not aiding this court to arrive at a proper decision.
As far as the Justice Department is concerned, the Justice Department is only implementing agency and recommending. As this decision.
You have recommended why you have reduced it.
No, I haven't reduced it.
It is the general manager. Are you not
No, no.
appearing for the general manager?
Yes, no, general manager, no, Lordship. Two things, sir.
Mr. Polita kindly appreciate, don't say. He had claimed 83 crores.
Correct.
You have reduced it to 74.
That is not say after investigation. That is what has been written.
No.
That is eligible investment. He can claim any amount, Lordship, but I'll have to spot verify and find out which is eligible.
What is your
which not.
basis?
Basis of spot verification, Lordship.
What basis?
Basis of spot verification.
What are the things you have taken into
I have
consideration?
taken into consideration machinery, including electrical installation.
So
that,
he is claiming 83.
correct.
You have not given an answer. You have only said 74.
So
The
that-
writ petition categorically mandates out the states that he has claimed 83 crores, but the general manager has reduced it to 74
Correct.
without any rhyme or reason. And not only that, the Empowered Committee has further reduced it and giving him only 14 crores. That is his case. And you are not answering, then obviously if tomorrow it is on inquiry, I will direct them to pay this on 83. Now, on 83, if it is paid out there, if any amount is to be then it will be recovered from the salaries of those who are hiring officials. Is it I make it clear?
Can it be in the first week of February?
Absolutely no. You want, I can have it tomorrow. Don't take this court for granted.
Alright.
That part I'll clarify. Lordship.
Only
That-
that affair.
that-
I don't need anything.
Lordship,
I don't, both of you, I'm telling
that
you.
I'll clarify.
What is your basis? You don't need to file affidavit. Only bring on record an instruction as to on what basis you
That
have
deduction.
arrived at a particular amount. Otherwise, this court was in your favor. But if you have not done it, then why the petitioner should be penalized?
That
And lucky and necessary, they can also recover from the lawyer, from you, for not informing your authority. I'll make that also clear in the next talk.
Alright.
My lord, though it's a contempt, my lord, there's an issue, my lord. That eviction is a forest eviction, which has been carried out, my lord, as per direction of the Honorable High Court passed in a PIL, suo motu PIL. And wherein, my lord, we are, due to non-carrying out of eviction, my lord, we had halted the process for some time, but my lord, suo motu contempt is also being running. My lord. These are the directions. The Poncharatna area, my lord, is a forest area.
Have you seen the notice?
I have not seen, my.
Then don't make your submission.
No, man, I just wanted to clarify.
No, nothing doing.
Madam.
First of all, why we should not have these people out there? This is a Sumoto PIL has been taken, it's a different thing.
Madam.
This is not being said on behalf of the.
Yes.
They are saying that this is roadside reservation land.
Madam.
That is what has been stated. If it has been stated in that notice out here that it is a roadside reservation land and the notices have been issued by the ASO,
My lord.
what is this business?
Yes.
Are you doing it? You are not doing it.
No, no.
Then-
Yes, Rodrigo.
Then under your circumstances, why you are coming?
No, my lord, since
If you
eviction-
if you are going to do it, you do it.
Well,
That is your lookout.
my lord,
I'm not saying on that. But the fact that these notices under 18.1 and 18.2 have been issued by officials by an ASO.
yes, yes,
What
that-
power does the ASO have to do that?
that's. My lord. I just wanted to point it out, my lord, because eviction is already carried out and finished.
Which one?
That Poncharatna area, if it's eviction at all, my
This is not Pansaratna.
lord. Poncharatna.
Then
It is not the forest.
this is not the forest state.
Oh, let me. I just wanted to apprise, my lord.
This is when the court has passed an order, then also you have not. Are you saying that the division bench order out here, and in spite of the division bench order, if any order has been passed by the division bench, then also when the single judge passes an order, this order is to be not regarded?
No, it has to be.
Then
No, my lord, since the area is Poncharatna, my lord,
So
I was
what?
informed, that's the reason I.
have
came
you
to this
seen
order.
the notice?
No, my lord.
Then don't come up with all this. Issue notice, making it returnable on. January 2024. The petitioner is directed to take steps upon the respondent number 1 and 2 by way of registered post, along with usual. The petitioner is further given the liberty to take steps by way of dusty, routed through the registry of this court, and file an affidavit of service on or before the next date.
For starting like the pointer putting. Good. By the order dated. Task force have been directed to maintain. And on December 23rd,
Mr. Counsel, tell me one thing. Why have you come before this court and filed against the notice? You go and reply. What is this filing of a writ petition against the notice? Is it without jurisdiction? If it is not without jurisdiction, where is the question of filing a writ petition? You reply to the notice.
we have filed notice. The reply
So reply, have they passed an order? The employees provision fund. Your employees provision. No. Yeah. Why should we entertain this writ petition at all? You have a fight with the State Bank. And because of that, you are not paying this. And what is happening actually to those persons who are entitled to that amount?
but in 1985, some special deposit scheme was launched. In of it. For that, we have deposited amount, and out of that interest amount, we pay that provision fund. The provision fund.
You deposited after 6 months or 6 years.
1972, we said
That was closed. What will the State
no,
Bank
not
do?
it. That was closed.
Then
that
what
was-
will the State, now tell me,
Yeah.
you deposit a particular amount
Right.
which was not within that scheme. Now, under such circumstances, they refunded the amount back to you.
Right.
and said that we are, and by deducting this 32 lakhs,
Yeah.
saying that this particular amount which was there, that we are keeping on hold, that will be subject to the outcome of the writ petition. That's all.
But-
Then under such circumstances, why it stops you from making the payment to the employees of the, and not only that, you have only issued a notice and you have rushed out there, taking into account that you have a fight with the State Bank of India for which this court should stay.
So, Lordship, main thing is that we have deposited it before the State Bank. And the State Bank have to pay to the Provident Fund. And the period that which irregularly we have deposited, that was come to know in the year 2009 from the letter. So, court has
State
not
Bank
said-
was to deposit to the Employees Provident Fund?
No,
No, you are to give. They have put it on a particular saving scheme.
Lordship, may I just point out
First of all, you answer to the query.
Yes.
Why have you approached this court under Article 226 against the notice? You reply,
what order was passed annexed 2671
1987, na?
1084 1084
1087, 84 is against whom?
against State Bank. 1084 is against Provident Fund, Union of India, and 1087 is we have repaid the amount along with the
No, wait, let us first look into,
10.
because now what is happening, you know,
Yes, Lord.
they are going to impose penalty.
Okay, that is why.
They are going to impose penalty upon you.
But-
They have only issued a notice to you
But-
as to why penalty should not be imposed.
But-
Why you are not replying and have
That-
approached
that
this?
was done in the, we have on 23rd. But the major. On 4/12/23, they have issued again one notice.
4-5
4/12/2023, that is not on record.
for
On,
what?
We have appeared before the Provident Fund and we have given them reply also,
Hmm.
and the order is reserved.
They've determined the order.
No, my lord, not yet passed the order.
They will pass the order. You reply. Where is that notice?
No, that is not on record also. It is on.
No,
the
no,
page-
not that. The impugned notice is where?
the last page
60.
was.
Page 60,
Page
63, my lord.
50?
Three.
53, no.
1084.
Which writ petition?
1084, my lord.
1084, page 52 is the
No, 63.
62.
63.
63. Yes. Whereas Assam Cobra is an establishment covered under the employees demand, and whereas under the provisions of 6 days so and so, is required to remit the contribution along with the administrative charges within 15 days from the date, whereas under section so and so, where employee makes default in payment of contribution or charges, the commissioner is required to recover by way of penalty against the damages not exceeding so and so. Now the scrutiny of the records restored for the remittance made by you during the so and so shows that there are certain payments which were made after the respective due dates, and the total amount by way of penalty and the amount of interest has been unrelated is under. You are entitled for an opportunity of being heard before the damages are levied. You are therefore availed this opportunity before the damages are levied and may appear before this court on so and so. In case you have already made the payment of so and so. So this is against the notice.
In page 67 also we have page
What?
To General Provident Fund. General.
What did you say? As the State Bank did not transfer the amount to the regional demand in spite of the year, we filed a writ petition in money against for a direction release the amount with interest. The regional provident fund had also made a party to the demand. As the state did not transfer the demand, we under compulsion had to make the deposit of this fund from the bank's own fund by incurring an additional. We crave for exonerating us from the default in making so. Then
Therefore, if they have given us cancellation of exemption to comprise under state refund.
Hmm?
Page 69.
This order says that it will be taken up on the next date. Then you got a status quo. So as of that, there is no order passed.
But if they have not court where
Very well. They have taken a long time.
No, my lord, I have obtained instruction, my lord, it is for a different period, not this period.
And it is a dispute between you and State Bank. How are you involving the employees there? They are not bothered.
Our
That
problem
payment is to be
the
made.
Interest to be, what interest we have deposit, incurred in that deposit, that to be transferred to us. Otherwise, how we can pay the officer?
You don't pay. You see, the payment is to be made by you.
Right.
The idea for or the intention, aim, and objective for you to deposit the money with the State Bank is to earn more interest. You could have done it in any place, or you can keep it with yourself. But the fact that you are to pay to the employees for Provident Fund, there is no quarrel that you have to pay. You may file a representation for the purpose of exonerating you or doing that is a different aspect of the matter, which they may do so if there is a possible thing for relaxation, if it is permissible. But how can this court sit over it and say that don't charge that? Tell me. You are challenging this too. We are to therefore look into. This court is only therefore to look into as to whether the issuance of the certificate notice on 30/12/2023 and the order on 22/1/2014 granting an adjournment to you to represent is wrong. We are sitting only as a judicial review. We are not sitting as an appellate authority. So, show me what is wrong. Your wrong is, what you are complaining is against him. Mr. KKD. Not
They
to
they
him.
have hold the amount.
Who?
State Bank of.
Understood. So that is, you wanted to earn more money for which you kept it with the State Bank. You may have kept it with HDFC Bank. You may entitled to damages from State Bank. That is a different question. We are not concerned. We are only concerned about the order which a notice which have been issued by them. Do you have a case against them? Do you have a case? No. Tell me. No, I don't think so.
But
Yes, madam. Here's a case.
but if Union of India directed State Bank to hold that money. That is the point.
Mr. Counsel, every Union of India, who? That is the Finance Department. The Department of Revenue has asked them. Does this Union of India and the Employees Provision Fund have asked them, the Labor Department? No. So you and him, there is no other way. You are bound to pay as you have entered into the scheme, you are bound to pay. And if you don't pay, the penalties will follow. So the only best thing I can do is, while dismissing your petition, giving you a liberty to submit a representation, and they may consider if it is permissible. And that's all. Nothing more than that I can help you with. Because what is happening otherwise, you see, many, sometimes it's very easy to get a stay. I sometimes tell many of the revenue councils, revenue means the taxation councils out there, it's very easy to get a stay. But the moment you get a stay, you are very happy, oh, I don't need to pay now. But at the end of the time, when the matter gets dismissed, then you are in trouble. The amount of interest which is being imposed. Many of I tell you about the incident when I was a lawyer. Remember, there was the Entry Tax Act 2001. That act was horrendously prepared. It's not properly made and all. So many of the petitioners challenged this petition. This court set aside that, the act. An appeal was prepared and the matter was pending before the Supreme Court. That matter is okay. While that was going on, the state retrospectively amended by making or correcting everything. Now, this matter was again put to challenge because now they became eligible to collect from retrospective period. So they challenged it. The court initially granted the stay. Thereafter, the act was upheld. Matter went to the Supreme Court. Supreme Court initially was following Jindal Steel's judgment. Then the matter was referred to a larger bench, 9 judges. 9 judges said that these are not compensatory. These compensatory tax are not like fees. And as such, you cannot apply the same yardstick. Now see the state of affairs of all these petitioners who were there had to sell off their business. Can't help it. Now the problem arises with you is it will keep on increasing. If you had paid that amount, had you paid them? Did you pay them an amount?
Paid. 1957 days what they were.
They have paid the amount.
No, they have no, till date no recovery made, my lord.
No, that amount was paid.
That amount was paid,
But
but the
the-
only question now arises as
That
as regards the
is-
penalty.
Yes.
The penalty you have not
Sir,
paid
sir,
because of the status, because penalty adjudication has not been done.
Sir.
So the question is they have to make the adjudication. As of now, we don't have any good reason for exercising judicial review. Now let me therefore dismiss this petition with liberty to you to represent. That is the only way out.
Already that we have represent also in that employee provident fund organization. The order is there.
When?
5/12/2020.
Then?
4/12/2020 they have it and we have appeared.
That is a
This is for
different,
different period, my lord.
that is
I have taken
different. We
instruction.
are not concerned with that.
Okay, that amount is also mentioned.
You have represented, but is it mentioned in the 412 order, their order? They have not.
No, not yet passed. Final order was not passed.
You see, we are not concerned with that thing. You submit a representation, they will consider. এখন লিখিব দেই 1084 of 2014. The instant writ petition has been filed by the petitioner challenging the demand notice dated 30/12/2013 issued by the Regional Provident Fund Commissioner for payment of rupees 35,22,822 as damages under section 14B of the Employees Provident Fund and Miscellaneous Provisions Act 1952, for short the Act of 1952, and rupees 22,66,574 under section 7Q of the said Act, as well as interest, as well as in full stop. The petitioner have also challenged the order dated 22/1/2014 issued by the Regional Provident Fund Commissioner in the said proceedings. The record reveals that the petitioner herein is a cooperative bank registered under the provisions of the Assam Cooperative Societies Act 1949. The Provident Fund account of the employees of the Assam Cooperative Apex Bank Limited, that is the hereinafter referred to as the bank, was managed by a board of trustees of the bank. It is the case of the petitioners that in the year 1975, with the concurrence of the Ministry of Finance, Department of Economic Affairs, Government of India, a special deposit scheme was implemented through the State Bank of India. The Board of Trustees of the bank accordingly opened and maintained a special deposit scheme account, being account number 1 with the State Bank of India, Guwahati branch. The interest for a calendar year was used to be released by the State Bank of India in the first week of the month of January of the next year. And from that amount, the provident fund dues of the employees of the bank were disbursed. In the year 1999, an amount of rupees 1 crore 1,03,17,176 was deposited, was paid by the State Bank of India through a banker check, being the accrued interest for that period against the aforesaid special deposit scheme amount. The Board of Trustees of the bank, instead of crediting the same towards the principal balance, had made encashment of the check, and a sum of rupees 23,17,000 and odd was temporarily kept in its savings bank account maintained with the Guwahati branch of its bank, so as to settle the dues of the staff of the bank who had retired in the meantime. However, on 8/1/2000, the remaining balance of rupees 80 lakhs was reinvested in the special deposit scheme account maintained with the State Bank of India, which was duly apprised to the Provident Fund Commissioner by letter dated 8/1/2000. Upon receipt of the said amount of rupees 80 lakhs, which formed the part of the principal of the said special deposit scheme account, the State Bank of India continued to release the interest accrued in the said amount. However, on 19/9/2004, the Assistant General Manager, SBI Guwahati, by the communication bearing number 55, informed the Board of Trustees of the bank that a said deposit of rupees 80 lakhs have been treated as irregular deposit in view of the objection reportedly raised by the Chief Controller of Accounts, Ministry of Finance. By the said letter, it was intimated that the State Bank of India may have to recover the interest amount of rupees 35,22,822 paid up to the year 2002 on the aforesaid amount of rupees 80 lakhs, if the Government of India does not accede to their request. On receipt of the said communication, the Chairman of the Board of Trustees on 24/11/2004 wrote a letter to the SBI Guwahati branch requesting for re-examination of the matter, and also stated that any action of the SBI towards realizing the aforesaid amount, that is rupees 35,22,822, would adversely affect the interest of the trust for no fault of its own. The SBI authority, despite receiving the said letter as alleged, stopped calculating interest on the above deposit of rupees 80 lakhs with effect from 1/1/2003 and sat over the matter despite objections being raised by the petitioner bank. The record further reveals that on 19/9/2006, the Assistant General Manager of the State Bank of India Guwahati branch wrote another letter to the Board of Trustees of the bank, thereby making a claim of refund of rupees 35,22,822 already paid to the petitioner bank, claiming the said to be ineligible interest. By the said letter, the bank was also the state petitioner bank was also entirely directed to forego the claim of any interest on the said special deposit scheme account with effect from 1/4/1999. On the ground forgo the interest on 149. The petitioner bank on receipt of the board of trustees of the petitioner bank in its meeting thereupon held on 9/10/2006 resolved to request the SBI authorities to release the said amount of rupees 80 lakh and also to release the pending interest on the said amount, besides requesting not to deduct any amount already credited in the special deposit scheme account of the bank. Accordingly, a communication was issued on 27/5/10/2006. In the meantime, the board of trustees of the petitioner bank, board of trustees and board of directors are different. The board of directors of the petitioner bank decided that the provident fund account of the bank be transferred to the central board of trustees, employees provident fund organization, and accordingly the board of trustees of the bank stood defunct with effect from 30/11/2006. In view of the above, the chairman of the board of trustees on 30/11/2006 intimated about the said decision of the bank and requested to transfer the balance amount to the account of the central board of trustees with up-to-date interest. On 4/11/2006, the Deputy General Manager, SBI, in response to the communication dated 25/10/2006, intimated the petitioner bank that a matter regarding release of the pending arrear interest on 80 lakhs with effect from 1/1/2003 and the refund of the principal amount had already been taken up with the controller of Guwahati branch, and the petitioner would be shortly advised. Nothing thereupon happened for another 4 years. Nothing thereupon happened as alleged in the writ petition till 16/1/2007, when the SBI authorities intimated the petitioner bank that the government of India had refused to accept their request, and accordingly the ineligible interest amount shall have to be recovered and the remaining balance will be transferred to the account of the Central Board of Trustees. It is also seen that there were various correspondences in exchange between the petitioner bank as well as the respondent, as well as the State Bank of India. On 9/6/2007, the corporate center of the State Bank of India had communicated the petitioner bank that the matter issue was taken up with the Ministry of Finance, Government of India, and their decision was still awaited. Subsequently, on 31/3/2008, the State Bank of India authority intimated the petitioner bank that a special deposit scheme account being also informed that it had been instructed to make a lien on the disputed amount of rupees 80 lakhs until receipt of the final decision from the Government of India as well as the controller. However, the special deposit scheme account of the bank was not transferred to the account of the Central Board of Trustees as however, the special deposit account of the bank of the petitioner bank was not transferred to the account of the Central Board of Trustees as have been alleged in the writ petition. It was on 15/9/2008 that the State Bank of India informed the controlling office that the controlling office had agreed to transfer the said account on completion of some formalities and accordingly requested the petitioner bank to send some suitable official for that purpose. The petitioner bank duly deputed a personnel to visit the SBI, and upon visit, it could be learned that the SBI authorities were seeking an undertaking of indemnity to the effect that in the event the Ministry of Finance makes any claim for refund of the interest paid, the same shall be paid by the petitioner bank. Upon getting the said information, the board of directors of the bank in its meeting resolved that an opinion of the Reserve Bank of India be taken in the said respect, for which the Reserve Bank of India was duly communicated. On 1/12/2008, the General Manager, Reserve Bank of India, expressed that the interest accrued on the petitioner's bank deposit after 1/7/2003 should have been paid to the petitioner bank by the SBI instead of redepositing the same in the special deposit scheme account. Regarding execution of the indemnity bond, it was stated that the Board of Trustees of the bank may take any appropriate decision. Upon receipt of the said opinion, the petitioner bank on 2/12/2008 wrote a letter to the Chief Manager, State Bank of India, intimating about the opinion of the RBI and also requested for transferring of the amount maintained in the special deposit scheme account to the account of the Employees Provident Fund Organization, excluding the amount of rupees 35,22,822, which according to the petitioner bank was to be retained in the special deposit scheme account of the bank till the issue is settled. Such request of the petitioner bank was accepted by the respondent State Bank of India, and accordingly, the remaining amount was finally transferred to the account of the Central Board of Trustees, and the amount of rupees 35,22,822 continued to be in the special deposit scheme account of the petitioner bank maintained with the State Bank of India. Thereupon, while the aforementioned proceedings were going on 21/5/2009, the Assistant Provident Fund Commissioner asked the Chief Manager of the SBI to transfer the amount of rupees 35,22,822 to the Central Board of Trustees, Employees Provident Fund Organization. Full stop. The petitioner bank had also, by the communication dated 18/7/2009, requested the State Bank of India to make necessary arrangement for transferring the aforesaid amount as desired by the Assistant PF Commissioner by communication dated 21/5/2009. To the said communications, the Chief Manager of the State Bank of India informed on 18/8/2009 that the decision of transferring the remaining amount will be this 35 lakhs.
No, Lord. It should be more because interest takes more.
No. You see, the amount has already been paid to the center. You see what they have done. You say this amount, the entire amount, only keep 35 lakhs, which according was the retained in the special deposit. So this 35 lakhs was the amount.
Okay. That was
So the remaining amount will be this 35 lakhs. The chief manager again on Iman intimated the petitioner bank that the decision of transferring the remaining amount, that is the amount of rupees 35 lakh 22,822, is still under consideration with the Ministry of Finance and accordingly requested the petitioner to wait for some more time. It is also seen that on account of the amount being not transferred to the Provident Fund authorities, the employees of the petitioner bank have been duly affected, for which the Register of Cooperative Societies had requested that the Chief Controller of Accounts, Ministry of Finance, Government of India, about the difficulties and also for release of the amount at the earliest. It is also seen that there has been various other correspondences issued by the petitioner bank to the State Bank of India, as well as also a communication to the Chief Controller of Accounts, Ministry of Finance. However, nothing was done, for which the petitioner bank had filed a writ petition before this court, which was registered and numbered as WPC number 1987/2013, seeking a direction from this court towards release of the aforesaid amount along with interest accrued thereon. While the aforementioned aspects were pending, a notice was issued on 30/12/2013 by the Employees Provident Fund Organization, stating inter alia that during the period from 1/4/2009 to 30/10/2013, there were certain payments which were made after the respective due dates, and the total amount by way of penalty and the amount of interest on such related payments were rupees 37 lakhs, 3 lakh, 37 lakhs 26,087 towards damages, and rupees 27 lakhs 54,403 towards interest. The petitioners were given an opportunity by the said notice dated 30/12/2023 as to why the said damages and interest should not be levied. This notice has been impugned in the instant proceedings. The record further reveals that the petitioners thereupon duly submitted their reply on 17/1/2014, stating inter alia that it was on the ground of a mistake of the State Bank of India in not transferring the amount for which the petitioner bank could not deposit the said amount within time. It was mentioned that an amount of rupees 35 lakhs 22,822 was duly deposited by the petitioner on 25/5/2012. Thereupon, a hearing had taken place on 22/1/2014, wherein the Regional PF Commissioner, Roman II, had duly observed that the liability to pay to the petitioner by the petitioner to the PF authorities within the stipulated time is the mandate. And as such, the payment having not been received, the amount having not been received from the State Bank of India of an amount that is rupees 35 lakhs 22,822, which is the subject matter of WPC number 1987/2013, cannot be a justified ground. However, an opportunity was granted to the petitioner to represent their case in the case on 21/2/2014 at 12:30 p.m. This order has been put to challenge by the order by way of the instant writ petition. The record reveals that both the State Bank of India, as well as the Provident Fund Authority have filed their affidavit in opposition. It is relevant to take note of that it was a specific stand taken by the State Bank of India that in terms with the notification issued by the Ministry of Finance, Government of India, dated 17/3/1997, fresh deposits under the special scheme was not permissible with effect from 1/4/1997. This was, however, relaxed up to 31/3/1999 as a special relaxation. The petitioner bank had deposited the amount of rupees 80 lakhs on 10/1/2000 in the special deposit scheme account maintained by them in the respondent SBI bank. Therefore, the interest of rupees 35 lakhs 22,822, which accrued by applying the special rate and already released to the petitioner bank, was liable to be recovered. It has also been mentioned that the Ministry of Finance, Government of India, have till date not given a decision as regards relaxation to be given to the petitioner. This court have also perused the affidavit in opposition filed by the Provident Fund authorities, wherein it has been categorically mentioned that there being a delay of 1957 days in depositing the amount, the notice was therefore issued asking the petitioner, thereby granting the petitioner an opportunity of hearing. This court have also taken note of the submission made by Mr. S.K. Chakraborty, the learned counsel appearing on behalf of the Provident Fund Authority, who submitted that the impugned notice was issued only granting an opportunity of hearing to the petitioner. And the impugned order dated 22/1/2014 had granted an adjournment, thereby enabling the petitioner a reasonable opportunity. This court have also heard the learned counsel appearing on behalf of the petitioner, who submitted that on account of the failure on the part of the State Bank of India to release the amount of rupees 35 lakhs 22,822, which have been kept on hold, the petitioner bank could not make the payment in time, and under compulsion had to pay it from its own account. Having heard the learned counsels for the parties and having perused the materials on record, the question therefore arises as to whether the instant case is a fit case for exercising judicial review, taking into account that this court is not sitting as an appellate authority over the decision, over any decision made by the respondent authorities. This court also is aware. This court also duly takes note of that the impugned notice dated 30/12/2013 30/12 grants an opportunity to the petitioner. An opportunity to the petitioner of hearing as to whether the imposition of damages and interest should be made by the authorities concerned, by the Provident Fund authorities concerned. The impugned order dated 22/1/2014 nowhere decides against the petitioner. Rather, it grants an additional opportunity to the petitioner to represent the case. Under such circumstances, this court finds no reason to interfere with the impugned order dated impugned notice dated 30/12/2013, as well as the order dated 24 na? 22/1/2014. Be that as it may, as the matter has been pending since long, this court grants an opportunity to the petitioner to submit a representation explaining the grievances, and on such application, such representation being submitted, the respondent Provident Fund authorities shall decide the same on the basis of the prescription of law. Under such circumstances, the instant writ petition therefore stands dismissed. However, subject to the observations made in the penultimate paragraph.
ভালো হয়েছে আমার প্রশ্নটা
বৰ্মন কৈ নাযাব আগৰ টেক্স খিনি একেই হ'ব।
But if 167, but we have already received all the amount.
You have received
Sure.
35 lakh.
35 lakh, then other interest also. Total.
You have received.
Sure.
You don't want to
No,
press.
sir.
The learned counsel appearing on behalf of the petitioner submits as the amounts which have been claimed in the petition. As the respondents, as the petitioner have already received the amount of rupees 35 lakhs.
About
35 lakhs, 22,822 from the State Bank of India, along with interest.
Sure.
The petitioner would not like to press the instant petition. Accordingly, the petition stands closed on.
Public.
Okay.
Hmm?
Itu takut tuh aku dah kan.
Oh, then?
Not appeared up to 24th of this.
What is this matter about?
So the company they have said that they did, but the government has taken the land.
They have acquired land.
Yes, take the land, and that possession certificate has also been given, but till now they have not paid the compensation. One part, of course, that has been admitted by the affidavit. Because of the transfer of the officer, they are unable to calculate.
Huh?
They- because of the frequent transfer of the officer, they are unable to calculate and pay the amount. In their affidavit,
My lord, in our affidavit, my lord, your lordship's record is running is 145.
Yes.
145.
145 paragraph 3, my lord, last, my lord, we have stated regarding preparation of compensation amount for the land handed over by the petitioner.
This compensation is under what provision? Fixation of land.
Fixation.
The amount will be way less, na?
But this
They pay you as per the land value, not land value. The compensation is just on the basis of because the land rates, revenue rate.
was it's the year 4. And apart from this, earlier they had acquired 7,000 something, and of that 1,500 figure has been returned back to us for participate. Remaining they have not returned back. So that would be- they have raised it. And of course, in the second part, they have admitted that 4,100 figures they are able to calculate because of the error of. Other issues, they have said that they have not acquired 7,000 something, but they have acquired 6,565 figures, the same paragraph. And
Paragraph
out.
3.
But earlier we have moved civil full court in honorable court. Where in their affidavit they have stated respect the order that they have acquired 7,000.
But is this a case of acquisition or is it a case of selling?
Sitting surplus of 7,000, so far the 7,000 party. Yes, 52.
Equity
That has been surrendered. But lawsuit will clear from
return back.
so page.
No, your prayer out here is for the purpose of returning that 5,524.
Yes, that is one. Second,
Then for
prayer.
paying adequate compensation as per the Assam Fixation of Land Ceiling Act, interest up to date for this 2152 figure.
Fine.
This is not again acquired. It has gone on ceiling.
They have taken back because the possession certificate also been issued by them.
So this is done under that There's a notification under section 7, the draft notification, the final notification is
RDR,
prepared.
RDR fixation was not in the tea garden, their act not applicable RDR. The government, what they have done, to formula.
Huh?
There is a formula they have adhered without one is two formula. The basis of that, they have equity.
Under what provision?
That is because there is an agreement, what they have stated, earlier you will can see the page 111. So for the
No,
2001.
if land has to be taken under the Assam Fixation
Yes.
of Land Ceiling Act,
Yes.
then
Subsequently, that
it can be taken,
Yes.
provided it does not meet within the ambit of section 5.
Yes.
Normally, a person can hold 50 acres, or another person can, a company or something can hold a particular, but as regards tea garden, it does not apply to tea cultivation. But anything which is outside the tea cultivation, which is given out there in the rules, that can be very well taken outside. They can allow you to retain certain amount for future cultivation for tea, this taken. So, anyway, your instruction does not
Well-
that the officials are there not inspired. What to do?
But-
Yes, what is this, madam?
Mal-
Unheard of?
Yep, yep.
Does it take for so many years for you to settle out?
Put that record and report back.
Required, you are to fix. You are saying that you are not being able to on account of frequent transfer. Transfer of what?
No.
Official.
The official.
What official? In the district administration, which officials are transferred? Except the DC and the ADC and the circle officer, who else are transferred? Are the Mondols transferred? No.
No.
These are nobody is transferred. And neither the Mondols or any other district. These people are only inter-district transfer. So this is a completely, completely.
My lord, maybe my lord, if time may my lord granted within that period of lordship, maybe.
Yeah. This the matter on 13th of February 2020. This court directs the respondent authority, more particularly the revenue department as well as the district administration. Which one?
Raido and Sagar. Raido and Sagar.
So right, district administration of Toraido to take effective steps so that the instant repetition can be disposed of at the earliest.
But
Necessary affidavits. The computation, the on the next date, the respondent authority shall apprise this court with certainty as to why the petitioner would not be entitled to the return of 5,524 bighas, 1 katha, 2 lechas of land, as well as also to the compensation in respect of 5,12152 bighas, 2 kathas, 1 lechas of land which was acquired on 30/9/2004. This court further directs the state respondent authority to compute the entitlement of the petitioner and place it before the court on the next day without fail.
Problem.
7.
Yes,
Referring, that's what Our, all of them.
It's covered. Two is covered. Yes, Madam, what do you say?
Lordship, as per my instruction, Lordship, process has been initiated prior to Act 2013 and so it has been.
Huh?
The process has been initiated before Act 2013 and they are
This is done under what provision?
giving compensation under
This is done under what provision?
Land Acquisition Act 1994. They are
Huh?
1894. They are.
This is acquired under 1894.
Yes.
And what is Mr. Sibolwa doing there?
No, actually it is to NHA is a wrongly imputed, it is a construction by NH division, but I have gone to the petition below. Notification is from 13. Some notification has come on 14. It is a lordship in last occasion, what I remember that to be decided by the authority. So whether it will be applied 1894 or 2013. That will be decided. That was the your lordship one
My
that will be
judgment?
there.
Award has been passed.
Or for-
Madam,
Sir.
when is the award passed?
2000.
Huh?
As per the 16 district.
Yes, when was the award passed?
As per petition of 2016, compensation started to pay since 2008.
Madam, kindly repeat, when was the award passed? Huh?
2000.
Award passed. Tell.
Sector 24. 30. Then sector 24. 30.
Then section 24, what happened? What does 24(1)(a) say? What does
Where no award for section 11 of the Acquisition Act has been made, then all provision of the act related to the determination of the shall apply, or where an award under section 11 has been made, then such costing shall continue under the provision of the Acquisition as if the state act has repeated.
what? Oh. The petitioners herein are aggrieved by the action of the respondent authority in passing award for acquisition of their land and computing the same in terms with the Land Acquisition Act 1894. Though the award was passed after 1/1/2013, 2014. It is the specific case of petitioner that the petitioner should be paid, so that the compensation ought to have been computed in terms with section 26 to 30 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Gusto. It is under such circumstances the petitioners have sought for a direction upon the upon whom? Kala, madam, on whom?
Now,
Upon the competent authority for land acquisition for reassessing the compensation in terms with the provisions of the Act of 2013. This court at this stage finds it very pertinent to take note of a judgment rendered by this court in the case of Sawarmal Agarwala and 27 others versus the Union of India and 9 others, dated 14/11/2023 in WPC number 4947/2014. Paragraph 18, 19, 20, 21, 22, 23, and 24 being relevant is quoted hereunder. From a perusal of the above quoted paragraph, it will be seen that if an award has been passed by the collector or the person to authorize as in the instant case, the competent authority of land acquisition The finality and the conclusiveness attached to the award cannot be unsettled by issuance of a writ under Article 2 to 6 of the Constitution. The person agreed. Person agreed, but person agreed. The person agreed. If dissatisfied with the quantum of compensation, can very well approach the respondent authorities, approach the collector of the district, who will be the district commissioner of, here it will be the district commissioner Karbi Anglong.
Secretary, Bodoland Territory.
What?
Secretary,
My lord, here it is a my lord fixed schedule area. So therefore, my lord, the Secretary, Bodoland Territorial Council, Kokrajhar, he is acting as a Kala. He will be within the domain of BTC authority.
Now, is it the person to whom the reference is given?
Yes.
Huh?
Yes. Kala. Kala, for the purpose of my lord, the National Highways Act, for the purpose of the present case, it will be my lord, the secretary. In fact, lordship can.
The person agreed. The collector of the district or and in the instant case, the competent authority for land acquisition, that is the secretary,
Bodoland Territorial Council,
Bodoland Territorial Council,
Kokrajhar,
Kokrajhar, for seeking a reference to the appropriate court, to the court, for compensation, for enhanced, for deciding on the quantum of compensation. Taking into account the above, this court therefore disposes of the instant petition with the following observations and directions. Number one, this court, in view of the above findings and reasons, is not inclined to issue a writ to the district commissioner of the district commissioner of
District Commissioner,
Kokrajhar. Kokrajhar, oblique, the competent authority for land acquisition, there's secretary,
my lord, the Bodoland Territorial Council, Kokrajhar.
Land Revenue and DM Department.
to redetermine the compensation as per the Act of 2015.
In fact,
Number
they have done it, my lord.
Who?
The authorities, if my lord may be pleased to come to my lord, the Solicium and everything, page number 368 of the writ petition. Page number 368 of the writ petition. 368. Some exercise has been taken. Undertaken. Page 368.
No, they have done it under the old Act.
No, old age, but there are communications prior to that, my lord. Lordship will kindly see. My lord, Lordship then kindly come to page 363. 363. This is a PWD.
Yeah.
363. 363, paragraph 1. The estimate of the land proposed for acquisition of the project is prepared as per LA Act 1894, which has been repealed and replaced by right to fair
No, no,
compensation.
this is a letter written,
Yes,
but
yes.
you have not passed the award as per this.
Award, but the final statement has been made. Lord, then my lord will
This
kindly
is the notification Annex 6.
notification, but it is a continuation. Lordship will kindly see, my lord, the quantum is also there.
Where?
Yes. In the notification itself, page 368 itself, Lordship will see.
Yes, show me.
Market value, interest 23.1.
So 23 is what?
By all day.
No, all day, but
Yes, that has been done.
23 is under the 1894 Act.
1894, then Lordship will kindly come to page 385, the last page of the repetition. Who is the authority? The
It is
authority.
Portland secretary.
Remove it.
That has also been
Secretary.
Yes.
secretary.
So he is the person. This is the
Understood.
authority.
That is okay. But
Right.
why you are saying that it has been done as per the new Act?
So it has been done, and exercise was contemplated, my lord, to be undertaken, but it has not been done.
So once that award has been passed, this court cannot direct redetermination.
Yes,
It has to be done by in a manner by which it is advertised under law.
yes, if I answer this,
To reference,
yes, my lord.
the district commissioner,
District commissioner will have no role here, my lord. It will be, my lord, the secretary, Rural and Territorial Council, Kokragar.
Further land revenue and PMP.
Yeah,
secretary,
Department Land and
it is a federal area. they will do
secretary,
Then
here लिखो, is not entitled to read to the secretary, Boroland Territorial Kokragar, number 1, 2,
Secretary Land and Revenue.
to
and adjacent
redetermine the compensation as per the Act of 2013. This court grants liberty to the petitioners to file respective applications before the secretary,
My lord,
Boroland Territorial Council, Kokrajar,
my lord.
who is the competent authority for land acquisition within a period of 45 days from today. Number 3. The Secretary, Boroland Territorial Council, Kokrajar, that's the competent authority for land acquisition. Upon receipt of the respective applications so filed by the petitioner, within the time permitted by this court, shall within 30 days therefrom make the reference to the court of the district judge. Kokrajar.
Kokragar.
Number 4. This court further directs the reference court, oblique tribunal, that in the eventuality it is found that the petitioner would be entitled to compensation as per the Act of 2013. No interest should be awarded on the enhanced amount for the period from the date of taking over possession till the date of filing of the applications by the petitioner before the Secretary, Boroland Territorial Council, Kokrajar. However, post filing of the application, the petitioners herein would be entitled to interest if there is any enhancement in the amount. Next. This court further observes that as the entitlement of the enhanced compensation would accrue from the date of filing of the application by the petitioner, if the possession had already been taken, therefore, it is of utmost necessity that there should be no delay, should not be any utmost necessity that there should not be any delay on the part of the Secretary, Boroland Territorial Council, that's competent authority for land acquisition, to comply with the direction for making a reference to the court of the district judge, Kokrajar, as directed herein above. Anything else?
Not the, so far as this court of Thane district that is concerned, there is one notification. Right now, I don't have designating certain districts that take up this land acquisition. Perhaps
I think Pokraja is there.
Because it is a
if
citizen
it
area,
is not
they
there,
have,
Your Lordship, I will hand over a copy.
I think
it is a
Pokraja
autonomous
has.
authority, they have their own rules and regulations. The autonomous authority, fully empowered. The code is defined here, statutorily defined.
Or we can put it the district judge Kokrajhar or
I think
the tribunal constituted by the state government
Lord.
in terms with the provisions of section 69,
Lord.
69 or 64.
64, Your Lordship.
No, not 84. You are looking into which act?
13 Act.
Ah,
64, Your Lordship.
64 or
Reference to authority 64.
the tribunal will be the authority so constituted by the state government
Lord.
in terms with section 64
64.
of the Act of 2000.
otherwise also, as per section 64, the authority is the district judge.
Understood. Now what has happened? What you have done is out here that you have not given to all district
No,
judges.
that-
You have limited that 4 districts for 1 district judge.
The authority, yes, you can spell out the designated authority. Designated authority.
Obliged.
Suffice. I'm obliged.
Made with the court.
Hmm.
My lord, this matter pertains to the, my lord, the cancellation of my lord, Mohol, the lease and also imposition of penalty upon the petitioner for default on the payment of the premium and the, my lord.
Yes, I remember this one. R.R. Gogoi was appearing. Now Mr. D. Gogoi is appearing.
My lord, my learned friend was instructed
Records.
to obtain some instruction on whether I have filed the renewal of the environmental clearance certificate and records were called for, my lord, on the last occasion by an order dated
Request some more
21.
time. We have called records from the DFO and also from the state authority, the CR. That body was headless, non-functional. It started functioning just 1 month or 2 months back. We request some more time. Everything will come. On the next date, I'll ensure when it comes.
Oh, this one, as to whether the Deputy Commissioner Sonitpur as well as the Member Secretary of the State Impact Environment, as to whether the petitioner had applied for renewal of the environmental
Yes, my
clearance.
lord.
So there was only one question, my lord, that certificate.
Oh, you are making the same submission again.
No, my lord, that,
This is a forest
that body, my lord,
department cost.
my lord, that body state, this is not a body. My lord. It was non-functional a few months back, my lord. It has started functioning. We have discussed, my lord, by next date, we can ensure it comes. My lord.
When? 90?
Next date, it's not right, my lord, probably 24.
My lord, any date convenient to my lord, then my lord, my learned friend, my lord can fix it. I haven't.
24, 25, I can bring it.
Any date, my lord, can fix it.
You don't have an urgency. They just stay in your favor.
I have a statement paper, but
There's no.
submitting my.
Have you given it for Mama?
Yes, sir, they have given
It has started,
But they are not also interested.
No, my lord,
You have a stay.
My lord, I have a stay on imposition of penalty, my lord, which you are.
So let it remain. In penalty, there is no interest on penalty. Why don't we issue a rule? There's nothing.
in fact, my lord, I was.
Yes, my lord can also issue.
In fact, my lord,
They are not
was-
interested.
yes,
Why
sir.
should we?
Yes.
You are enjoying a stay.
Yes, my lord.
So enjoy it.
my lord, in fact, I was acceding.
No,
to
no,
that
no,
point.
no.
That blacklisting we may revisit it. That point I can accede, my.
What?
His blacklisting is also blacklisted. That can
My
be
there-
that
there
can
is
be
one
revisited.
There is one aspect which my learned friend is correct, my lord, because I have been blacklisted for 5 years. By
That
same
period is over.
period is not over. It's about to be over in 2028 when the lease will come to an end. If lease comes to an end in the year till 2000,
My lord, that blacklisting restrains him from participating in any other mohols.
Okay, we
That I'm
stay
going
that,
to accede.
we stay that
Yes, ma'am.
Yes,
blacklisting.
that I can accede to, my lord. But my lord, that record, we are serious about it, we're bringing the record to 24, 25.
Okay.
After Thursday, to put it.
This court, by an order dated 21/11/2023, had directed the Forest Department to produce the records, as well as the counsel appearing on behalf of the district administration to obtain instructions from the Deputy Commissioner Punitpur, as well as the Member Secretary of the State Environment Impact Assessment Authority, Bamuni Moidam, as to whether the petitioner had applied for renewal of the environmental clearance and fixed the matter on 12/12/2023. On the same date, neither the Forest Department nor the district administration had counsel appearing on behalf of the district administration have produced such records and sought for time for which the matter has been listed today. It is further seen that today also the councils representing the district administration as well as the Forest Department have sought for an accommodation as regards the records. On the other hand, Mr. H. Buragohai, the learned counsel appearing on behalf of the petitioner submits that on one hand, the petitioner, the respondent, on one hand, the petitioner has been blacklisted, and on the other hand, the respondent authorities are delaying the disposal of the instant proceedings. This court is of the opinion that as there has been a delay caused by the respondent authorities in disposal of the instant proceedings, the right of the petitioner.
Page 246 is the order. 246 is the order, which clearly says that, may I read, my lord? It is debarred from participating in the sale process.
And there is an order
246.
dated 26/3/2021, whereby
It has
the
been
petitioner has been debarred from participating in the sale process of any fresh mineral concession in the state of Assam for a period up to 5 years from the date of the issue of the said order. The said restriction, in the opinion of this court, becomes unreasonable. So accordingly, this court therefore stays the debarment of the petitioner from participating in the sale process of any fresh mineral concession area in the state of Assam, as ordered by the order dated 26/3/2021. This court, however, this court have also heard the learned counsels appearing on behalf of the respondents, and from them, it does not inspire the confidence of this court as that they would be in a position to produce the records as sought for by order dated 21/11/2023 in the near future.
No, on 25th we'll bring, my lord.
You are not bringing it.
No, I'm bringing, my lord, that body was headless, non-functional.
What is a headless, or you
It was
are
not functioning,
initiating
my lord.
action against somebody out
But
there,
that
and
body, state impact body was non-functional. It was not functioning, my lord. There was no chairman, my lord. So we had to communicate. Only from November, my lord, or October, or the last part of October, November, it had started functioning, my lord.
he is not interested. Not in producing the report. Accordingly, list the matter on 12th of March. On
My lord,
which
that
date?
other blacklisting part, I know from first date, my lord, I was saying that
No,
we can
he was
revisit.
honest,
my
my lord,
lord.
he was
Yes,
telling me, but
I was first date, my lord, I was saying.
he, in fact, on the first
On the first date, I was not the judge. I would have otherwise passed the out. But as of now, the only reason I find opting that order is non-production.
I'm highly obliged. If somebody has to give, my lord. The authority was not there from whom to ask for, my
So they are not interested. I am not putting the blame on the council. I am putting the blame upon
Marvelous,
the
man.
authority.
highly obliged. My lord,
Oh, Fancy Bazaar is exclusively the domain of Mr. M.J. Boru.
my lord,
Yeah.
That
Say-
L said, my lord.
their LOP inner links, my lord, page 36 onwards, my lord, and they paid the registration fees as well as the rent. But my lord, page 47, their problem started, my lord, from outsiders occupied. And there is two prayer, my lord, to evict them and to give them a.
Who are you?
We are the fire victims because this was prepared long back. This honorable court directed to prepare a list of class 2 fire victims who are not given inside, but they are also some rights there.
You are the list of fire victims.
Yes,
Right.
category 2. So we are LOP, my lord. Our notified area is
This is another association.
my lord, no, my lord, association is name, my lord. The category 1 case your lordship has there.
No, I have heard about the list of fire victims class
Category
2.
one.
I think it is Justice Biswas order.
Yes, yes.
Huh? I remember
Yes.
the Justice Biswas order says that those persons out there who have had the allotment out there and had a continuing allotment, they come under class 1. And who did not have it at that point of
Expired.
time but were expired, they will be class 2.
And they should be also given the chance.
In other words, those category 2 will have no document in their
Hello.
favor.
Now-
Nothing to show.
The GMC will say, my lord, they have prepared a list, notified area is given. My lord, their registration fees also accepted, my lord. And then they are paying rent, but they cannot do business. Because,
Why are you paying rent?
because,
Show
I-
me,
because
show
my
me
lord,
which rent you have paid.
yes, my lord, pay. First, the allotment letter pays 36, my lord.
Huh?
Allotment letter kindly say page 36 and 30. There is
No, forget about the allotment letter. Now let us see when you have paid rent. When did you pay the rent?
annexure E page 40, my lord.
Paid?
Some of this I, yes.
No, some of these would not do.
No, my lord, this is
No, this is security money. Where's the rent you are paying?
rent, my lord, annexure, my lord, 42, my lord.
Page
Two-
42 is
2000
what?
is
This
the
is
rent,
again
man.
registration fees.
Registration fee.
Where is the rent you are paying? You are not paying rent.
No, paying rent.
Where?
It is with me, my lord, but I have
Where?
to bring it to
With
the-
you? What am I going to do with you if it is?
My lord, kindly
Yes, Mr. Bora.
page for, my lord, kindly see the orders of this honorable court, my lord. January.
No. You. Why did you make a statement outside that you are paying rent?
My lord,
I know that you are not paying rent.
no, my, I am LOP, so I should pay.
Yes.
Initially, they were the LOP.
Huh?
They were the LOPs of LPETA.
Huh.
But they say that during the COVID, some other person has got it. So ultimately, the eviction was taken up. Eviction they evicted. In the meantime, there is an implementation saying that then the
He is appealing for whom?
newly implemented.
What is that association?
It is another association.
They are actually street vendors in
And
and
that is
western
called
side there, like, and there is order also in their favor. They create a vending zone, and now
No,
this,
the vending
Another-
zone is on the first floor.
that is the SS road. Your road is
that is different.
difficult, but
Then
Same building in the first floor.
so
This is mezzanine floor. That is now in the ground floor in the second.
they are not connected to. We are notified area of El Pattern, my lord. They are vending street vendors.
Ah,
maybe.
No,
Our problem is that they are interfering with us. That is
they are interfering with you.
yes, that
That
they are evicting.
impeding association.
Yes.
Yes,
Now,
why you are not
Another
doing
association.
something?
Now, my lord, evicted there. The moment the eviction was taken up, my lord, the moment their concern has been taken care of by GMC, then the implementation took place. Now I have to file my affidavit.
But 4-1, kindly see, my lord, last year, judgment 4-1, my lord, what honorable court says in this, that evict them and give. So one part eviction is done, my lord. Now second part, my lord, this LOP should be given, my lord, as per specification number, toll number, page number. My lord. That part was not. Then they are now waiting.
I have passed two judgments.
Yes, my lord.
One is the SS road.
SS road and my lord, his brother.
This is-
and one which they only had only 2 egg shops down
Yes,
ground
yes,
floor
but your lordship has passed this up when.
on that.
But they are class
Now
one.
that is inside.
Yes, class one.
Now what is outside?
Outside
Outside there is another matter. There are 2 other matters where there is another L pattern. There were these people have been asked to reside and they were having a that is some Northeast traders or some another
Yes,
traders.
Fancy with a group of traders.
Group of traders. So they say that out there
They
that
want to
look
sell it.
here,
Yeah.
we are now paying on the front line side. There are certain street vendors who are doing other business. Now there is an order of Justice B.K. Sharma out there to the effect that they should be only permitted to do the same business
business.
for which the AI has been given. Their only anxiety out there, I think Northeast, no?
No, Fancy with a group of traders.
No.
Fancy with a
Something,
group.
so their only anxiety is that they should be allowed to do something more than that.
They
That
want
is
to
the
sell.
case of was made by
Kollap Kotoki was there.
another one.
Some Bodley was there. Some Bodley was there.
Yes.
Fancy with a group of traders. They want to sell the things that their building persons from the building were selling.
And Kollap Kotoki was for the other side, who was saying that they are the
They represent those persons in the building. They don't want that.
who
other-
is being affected if any other business is being carried out. Now these are where
These are in the.
there is one section who he has been given there. Now where do these people come in? The L pattern is where?
Inside.
Inside the railing. Inside the railing. They are
Northern side.
the railing.
They are inside the ring.
Yes.
They are inside the railing.
And there is a direction of this honorable court, may kindly go.
And now they are also, you have given them the allotment
No.
to
They are
Mr. B.D.
something.
Goswami.
They are different. The implementers are different. They will be. They are another association.
Hmm.
They are also pending by that.
Pending zone should be created first, then allotment should be given. That stage have not passed. So whether pending zone is created or not, it is game. But in my site, my lord, they have no clash. Let them create a pending zone. Give. I have no objection. But we are allotting. We have given allotment. Then we pay this registration
Now-
fees. We pay the security money.
His PR has been taken care of, but in the meantime, the everything has been done. I have to file my affidavit now.
Now, my lord,
Yeah,
kindly
yeah,
see, my lord, this
yeah.
honorable court's order, my lord, kindly see, my lord.
Mr. Borua, whenever you come with this Fancy Bazaar's case,
Like, he has multiple
which you
cases.
have complete monopoly of.
No, my lord, no, my lord. Only
He-
two.
More
Mr. Borua,
than
tell
10
me,
cases, more
he
than
has
10.
monopoly.
Only,
Monopoly, my lord.
Huh?
my
Oh,
lord, my lord, only,
More than 10 cases are there. my lord.
only two cases, my lord. One is, my lord,
so where he has complete monopoly, you make a chart. Who were your clients earlier, now, and present, and
Hello.
for whom you are before.
category one,
The entire area, my
category one, my lord, your lordship has passed an favorable order. Now they approach category two, they are waiting for 20.
Understood. So we will have it some other day when we are filing
My lord,
affidavit.
my lord,
What's the 2 week time left?
my lord,
This is the matter again on
Let's go first week of February.
on
I-
15th of February 2024.
My lord, my lord, they are heavily behind me because these
Heavy-
persons are without business.
Heavily behind you
My lord, they
as
are
a
talking
client or
every episode they are
MJ
waiting.
Borua as a lawyer.
My lord, kindly see, my lord, this honorable court's order, my lord.
No,
They have
it's
no
okay.
time
We
to
will,
publish on report.
Mr. Borua, we'll look in. It's the matter again on
Then, my
15th
lord,
of
January, my lord.
February. No,
That's February.
15th of February 2024. You will stop. The GMC authority shall file the affidavit without fail by 8th of February 2024.
Regarding
This
public,
direction is being specifically that the DMC authorities have been specifically directed to file the affidavit in order to clarify as regards the present status of the petitioner association vis-a-vis the
respondent number 5.
respondent number 5.
that order was passed, my lord, in May. My lord, nothing that in same order. That is why I.
But you make a chart.
Chart I have prepared actually, your lord. Today I have not this. Obliged.
For this one,
Yes, I was supposed to file an affidavit, but I the number which I have, my lord, we are not.
Yes. Madam, did you get your instruction?
I did one more district that is from here. One more district. Last time I have
No, I asked somebody else. Mr.
RBI
H.
company
Uraguha.
has-
Yes. What is what is the status as of now? Is it still a bank, non-DI bank or something?
I have informed, I have received the instruction, your lordship. They are
Non-banking.
functioning as NBFC, your lordship. NBFC, and they are not permitted to accept deposit from public, your lordship.
As of now.
As of-
So then in that case, in view of that particular thing which they have done, we can close it. In Tinsukia, Dibrugarh, you have allowed them, na?
Yes, that Tinsukia is also.
So now Tinsukia also you are allowing them. So
They
what
are-
remains? This is Dibrugarh and this is Tinsukia. In both places you are allowing. So now, in view of this, nothing remains. We may observe that. And you are concerned with not to enforce.
Highway.
Here it is mentioned, however, from the existing records available in the office of the undersigned, that is the district commissioner here, there seems to be no indication that any of the branches of Northeast Region Fin Service Limited is currently closed based on any order of the district administration.
Morigaon already closed, my lord. Dibrugarh closed. Tinsukia.
Now Dibrugarh opened. Dibrugarh opened it. This is the instruction. The circle officer of the district was directed to inspect the remand and to seal those defaulting non-binary profit to restrain them from operating in the district and report remand. Otherwise, another order was passed by the so on remand other such three numbers of AI allowing to operate in the sequence. Moreover, on scrutiny, it is evident that the said companies were registered as non-deposit then, whereas it is further observed that they have failed to submit monthly statement of their business transactions in the Dibrugarh district, including the copy of the file as PTC. And on 11th of September 2014, so and so it is seen the RBI had granted the certificate of registration in favor of these financial in commence and carry on their business of so and so without accepting. Further, on scrutiny of the documents submitted by them, it is evident that these are registered as non-banking so and so. Since the regulatory accepted of these financial institutions lie with the Reserve Bank of an in pursuance of the so and so, the above mentioned India are hereby allowed to operate the business in the Dibrugarh district. Dibrugarh, it has been allowed. So, anyways, it being a non-banking financial institution without accepting, till they remain as such, they would not come within the ambit of this act. Isn't that right? Where's the act? We can dispose it off in this term. That they would not come within the act, meaning of this act. 2C. Now, they would not come within the meaning of section 2C. Are you going to come? means an individual or an association of individual or firm or company registered under the company and carrying on the business of receiving deposits under any scheme or arrangement or in any other manner includes the non-banking financial institutions as defined under so and so, but does not include corporation, corporate owned or controlled by or the now, what is as per 4451C for 45 1C and 1F? What are those?
Not non-banking.
But no, and any manner and include the non-banking financial institution as defined in section 45 1C and F of the Reserve Bank of India Act. Oh, I mean, if I credit information, what is this? The section 451 or what?
45, 45, 1.
45 1C is not there. 1B and C is there. Where is F? It can't be. Huh? Very wrongly written. What is NBFC must be defined somewhere. Banking, financial. where they have taken into account non-banking financial. Here. 45(8). Provisions relating to non-banking financial institutions receiving deposits and financial. Yes, 45I. C. The financial institutions means any non-banking institution which carries out the business or part of the business, any of the following activities. Financing, whether by way of making loan or the equity of the of the carry any of it. Now kindly come to this Reserve Bank. 45 Roman 1, Roman I. Okay. Now kindly see C. Finality and includes the non-banking financial company as defined in section 45 Roman IC. This is financial institution. We are not concerned with this. And F. Now F is important. Non-banking element means a financial institution which is a company. A non-banking financial institution which is a company and has its principal business of receiving deposits under any scheme arrangement or in any other manner, lending in any manner. That such other non-banking or class of institution as the bank may, with the previous approval of the central government and by notification in the official gazette specific. So, if the bank would mean the Reserve Bank may specify. Now the question is, have you specified this? Because here the definition does not only include, it is not only says about a financial institution which is a company, that will also be a non-banking financial company. So financial institution is defined out there in 45(1)(c) IC. Then a non-banking which receives, and the other is the Reserve Bank may nominate. Now, if it is nominate, then in that case it becomes requirement is there fulfilled, isn't it? Mr. Munir. See, the definition is not there only. And carrying on the business of receiving deposits under the scheme or arrangement or ENI and includes non-banking so and so as defined under 45 I, C and F of the Reserve Bank of India. So I, C is okay. F, there are three things. One is a financial institution. So a financial institution will again go back to 45 IC. Roman 2 is receiving deposit, which you are not. Number 3 is any other with the reserve. Has the Reserve Bank done in?
We have specified them as the non-banking financial.
No. Have you notified?
In the Gazette notification, yes,
No,
but
no.
I have
That other non-banking financial institution or class of institution as the bank may with the previous approval of the central government and by notification in the official gazette specified. Have you done so?
that part, Your Lordship, I have to
So
update.
this is a delegation which has been given to the Reserve Bank to specify any other. But another very interesting is why I am saying this is very relevant. Where is otherwise in this act non-banking financial institution who does not receive? Where is it? Because here if you see, financial institution means the financing whether by making loans or advances or otherwise of any activity other than their own. So financial institution will be there. But those which are non-banking also, which are financial institution, non-banking financial institution, but that particular bank does not receive deposits. What do you how do you notify them?
Lordship, we have issued a certificate, Your Lordship, in the writ petition.
Understood. But do you include them as non-banking financial company? Only see non-banking institution and non-banking financial company. Now, is this a non-banking financial company?
Yes, Your Lordship. It is
Company.
company.
Now, if it is a non-banking financial company, would it come within the ambit of this 1C F3, 45(1) F3?
Regarding the notification in the official gazette, Your Lordship, whether they have notified or not, that have to be.
I think you
assured,
need
Your
to
Lordship.
find out.
Have to find out.
Because this, the moment if I pass any order without taking note of this, may have a list the matter again on 5th of February.
Can it be after 10th?
10th of February. Okay. It's the matter again on 12th of February 2024. In the meantime, Mr. H. Purago and the Learned Counsel appearing on behalf of the Reserve Bank of India shall apprise this court as to whether the petitioner company would come within the ambit of section 45 Roman 1 Roman I 45 I capital I F bracket of F of the Reserve Bank of India Act 1934. So this court have also taken note of the instructions so placed by Miss M. Burman to the effect that in the district of Dibrugarh and in Sugia, the district administration have permitted that those non-banking financial institutions that have permitted the petitioner company to operate. The said instructions are kept on record and marked with the letter X and Y.
Okay.
I give it to him. Yes, anything? Oh, that too, yes. What happened? That only happens at the last.
Item number
11 one.
as per communication, by the order dated 8/1/24.
Madam,
Next
tell
is
me, have you read this document?
Malak.
What does it say? Read it.
Malak, my letter is not Malak. Next page.
No,
Malak.
no, the letter of the additional district commissioner. Read it.
Yes, Malak. It is written by me, written to me, Malak.
Yes,
next
yes,
page,
read that.
next page is Malak. Action taken by the Malak.
Will
Revenue
visit the
department.
land acquisition branch office of the Sri Kamrup on demand at 11 a.m. in connection with the matter pertaining to acquisition of land and payment of finance.
Follow-up action has been taken, Malak. Please to
Okay.
fix the date, time.
Taking into account the instruction which have been placed by Ms. U. Das, the learned additional senior government advocate, to the effect that the Special Secretary, Revenue and Disaster Management Department would visit the land acquisition branch in the office of the DC Kamrup on 11/1/2024 in connection with the matter pertaining to acquisition of land and payment of compensation under LA case number 6/89. This court fixes the matter again on 22nd of January 2024.
Maybe granted some more time, Malak, so that
Why?
we can
This is
give
on,
Malak,
he is doing on 11.
Malak, we can give some Malak.
No, no.
Of that.
This is a very old matter. On 24th of January 2024. For an update as regards the status for an update as to whether the petitioner was paid the compensation in respect of the 2 kathas of land. 2 kathas, huh? The matter be listed at the top of the, shown as in the top of the list. The instruction. Yes, Mr. Putra. What are you doing so late? Something must be very urgent. Yes.
So this matter is similar.
my lord, allotment of petrol pump.
Oh, yes,
So today it is not.
I remember.
I don't think on the last meeting, my lord, he was pleased to, my lord, direct them to obtain certain instructions. Particularly, my lord, selection of 4 candidates.
Where is he? Mr. Person is not there.
Lordship may reject the matter on subject to convenience, my lord, on 23rd of January.
There's a matter on 23rd of January. The top of that is.
And
Taking into
interim order.
account that none has appeared on behalf of the Indian Oil Corporation on call.
And interim order, my lord, may allow to continue.
Interim order passed earlier will continue till the next